Your Lordship. My mistake. This person has not been released. Applicant was in custody for years. Your Lordship needs to grant bail to the other accused person, accused person. They haven't released. Lordship, let it be the last matter of tomorrow. Lordship, I won't make any argument. I will see.
Lordship, may I submit, Lordship? Lordship, actually, I have one matter in the entire circuit, Lordship, in the anticipatory bail, Lordship. If your Lordship kindly take up the second half, Lordship.
What is the matter?
Anticipatory bail, Lordship.
One matter in the entire circuit. Tomorrow at the top.
Tomorrow. Okay.
Yes.
178.
But at Calcutta.
170. Today's please 178.
Yes.
Lordship, may I mention? Lordship, item number CRM NDPS 705 was initially on list on 18th August, 18th September on item number 14. Now it's in item number 160, Lordship. And
No,
the
sorry.
reviews are large on already. On
No.
Lordship, you
No, refused.
fix it.
No. Next. I call the list here.
One anticipatory bail matter.
You know.
Admission of application of the next item. Kindly release them.
Mention before the next circuit, Mr. Shah. We don't want to burden anybody else. Come before the next circuit and mention. I pass for it. You are reading the ordering portion only. Can. In view of the above observations, MAT 168 of 2023, along with IA number CAN 1 of 2023, are disposed of without interfering with the first impugned order, dated August 24, 2023, passed in WPA 2103 of 2023. Insofar as the second impugned order dated September 15 is concerned, same is modified to the extent that the cost of rupees 5 lakh imposed on the CID is set aside. However, affirming the other portion of the order whereby the recall application filed by the CID was rejected, the aspersions cast against the CID in the form of questions raised in the order dated September 15, 2023, being without any apparent basis, are also expunged from the order dated September 15, 2023. The CBI and ED will be at liberty to approach the trial court for making appropriate prayers to file additional supplementary charge sheet upon further investigation and take necessary steps for conducting the trial as the investigating agencies in charge, stepping into the shoes of the CID. The petitioners will also be at liberty to approach the trial court by citing the order of the learned single judge dated August 24, 2023, seeking a further fresh de novo investigation. No orders to cause urgency report. But you will have to seek that before the trial court. এটা আপলোড করার ব্যবস্থা করবে। Next.
It will be uploaded by
We hope by an hour should be
all of
as fast as possible so that you can take your necessary steps. Yes.
Yes.
Right. Thank you.
Your Lordship, item number 2 has wrongly appeared before this court today as because the learned counsel was appointed 2-3 days back and he has not received the paper book or any.
নামটা বাবার নাম চলে এসেছে। অ্যাপেলের মেন ফাইলটা কোথায় গো? মেমোটা কোথায়? না মেমোটা চাই, অ্যাপ্লিকেশনটা চাই। মেইন অ্যাপ্লিকেশন নেই কেন? এইটাই মানে অর্ডারটা কিসের উপর পাস হয়েছিল? জেল অ্যাপিল। আচ্ছা আচ্ছা আচ্ছা। The name was wrongly mentioned as Bishal Orao. Bishal Orao is the name of the father. Shankar Orao is the person. So for the correction of that only it is appearing. The name of the appellants had been mentioned as Bishal Orao and others instead of Shankar Orao and others in the order dated September 15, 2023. Full stop. Let such inadvertent error be deemed to stand corrected, and the name in the cause title should read as Shankar instead of Bishal. Next. হ্যাঁ, যাতে কারেকশন করো, লেট বি কারেক্টেড তো বলে দাও। যা স্টেপস না নিয়ে নাও। সিস্টেম বলে দিতে হবে কিছু, কি বলবো বলো? Let all consequential steps be taken by the concerned department. যা যা করার দরকার করো। Yes. See? Yes.
In item 3, I appear for the respondent.
Yes, what
Your lordship, to appear on-
is the correction?
Your lordship, in this matter, it has, as there is no logim, I had to mention it before your
Oh,
lordship.
acha, right.
As it would have been as FMAT first miscellaneous appeal, your lordship, it has been filed as AMAT, mandam.
But they have challenged an order, injunction order of the junior division where the suit value, my lord, is 100 rupees.
No, what?
Yes, my lord.
The appeal is not maintainable in any event.
Yes. They have come up directly.
I've got a copy of the plaint.
Lord,
Yes, that-
Junior division in any event, there we need not record the plaint.
Lord, yes. It is that
Junior division, it has to go before the district judge.
annexure P12 of the stay applications.
Yes, right.
In my copy, there is no pagination. But it is annexure P12 to the application. The suit is
Had to
valid.
be filed before the learned district judge. So we'll hold the appeal not to event, we'll correct, make the necessary corrections, dismiss the appeal as not maintainable with liberty to approach. Thank you for pointing out, yes. Learned counsel for the appellant points out that the appeal was erroneously classified as MAT instead of FMAT, full stop. Let such error be rectified accordingly by the concerned section, full stop. It is further pointed out by learned counsel for the respondent that the appeal has been preferred against an order passed in an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure by the learned civil judge within bracket junior division, comma, which appeal has to be preferred before the learned district judge concerned. Full stop. Next para. Upon a perusal of the memorandum of appeal, comma, we agree with such view. Full stop. Accordingly, MAT 125 of 2023, comma, is dismissed with liberty to the appellant to prefer an appeal against the order impugned herein before the concerned learned district judge. Full stop. No order is to cost. এই অর্ডারটা হয়ে গেল, অ্যাপিলটা ডিসপোজাল হয়ে গেল, কিন্তু এটা কারেকশনটা করবে অফিস। ভেরি থ্যাংক ইউ। Can such and such is accordingly disposed of as well. যদি আমরা টাইম পেতাম অ্যাপিল হিয়ারিং নিলে 90% অ্যাপিলের নামিয়ে দিই। সব ছোট 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 অ্যাপিল। Yes.
Now for the state, is it the key where your lordship has pleased to release the accused person on a appeal bail, but the learned trial court is not receiving the bond because the lower court record is not with them. Well, let's kindly direct the learned trial court to act on the skeleton because they used to have a skeleton of the LCR. And
Learned counsel for the appellant stroke petitioner submits that although an order of bail, although bail was granted to the appellant stroke petitioner video order dated September 15, 2023, comma, the learned trial court is not acting on the same in view of non-availability of the records.
original lower court's record.
Non-availability of the original lower court records. Full stop. Next para. However, comma, the effect of the order cannot be frustrated on such frivolous ground full stop. Accordingly, it is expected that the learned trial judge shall act on the basis of the server copy of this order, comma, coupled with the skeleton copy of the records, which is available before the trial court, comma, to give effect to the order.
Well, similar order should be passed in item number 5.
This was 4.
This was 4.
5 Dako.
No, 5.
Just, we are passing the same order.
Well-
Thank you. Same order.
Great.
Order date is same.
Order date is 15th of September.
My lord, I appear for the appellant,
Yes.
and I'm being led by Mr.
Yes,
Chatterjee, he's on.
I'm appearing for this.
Yes, yes.
For the
Yes.
appellant, man, in this matter. On last occasion, your lordship directed us to.
You are Mr.
serve the-
Shubham Ghosh.
Yes,
Yes, Mr. Chatterjee. Sorry, please continue.
Yes, my lord. And on last occasion, your lordship directed us to serve on the state, my lord. My lord, as per my, my lord, Mr. Ghosh, my lord, will say that it was rejected, my lord. After that, it was, my lord, served through speed post, my lord. So, my lord, probably he has filed an affidavit to that effect.
but the affidavit of service is getting affirmed.
Service has been effective. You can file it during the course of the
Yes,
day. Yes, he can file it during the course of the day. What is the matter? So what?
Yes, my lordship.
Yes.
My
What is the
lordship, my lord, on last occasion, your lordship was pleased to allow the section 5 application. My lordship will kindly take the impugned order, my lord, passed on 12th May 2022. Only on the ground that it says no public element, and after pendency of 12 years.
No, it was held that it was a private contract. Satisfy us prima facie that it is not so.
Yes, my
At
lordship
least
will
prima
kindly
facie you have to
take.
satisfy. Yes.
Yes, my prima facie definitely, my lord. My lordship will kindly takes the impugned order, my lord, which was first, my lord, challenged in the writ petition, my lord. That was an order dated 28th March 2010 at page 60, my lord. Page 60, my lord.
Page 16 of which can?
Well, I'm extremely sorry. Well, it's page. It starts from page 80, my lord.
80?
Well, 80, my lord, of the stay
80.
application, my lord. Of the stay
Yes.
application. 79, my lord. It starts from 79.
Right, right. So what was done by this?
Malak, what has happened? Malak, there was the company took a loan Malak, from the Industrial Development Bank. Malak, after that, Malak, an OTS was executed between the bank and the company herein. Now, Malak, we have paid already 95 lakhs as per the OTS, but it was beyond the time period. Now, Malak, through this order, Malak, Lordship will kindly take the last portion of the order at page Malak 82.
Yes, why is this not a private contract?
Malak,
You
because
carry
Malak,
enjoyment in interim order in the writ.
yes, I obtained an interim order. There was a specifically oppositions were given. Reply was filed just pending since 12 years. Now, only this point was never asked before any point of time. This is for the first time this point was taken by the honorable court.
That's a very strong ground, Mr. Chaudhary. You are right. But I mean, what is the public element at all? I mean,
But the order itself says that at page 82, paragraph 17. But though it is a contract wherein the public money used to be Lordship kindly sees WBIDC is a company fully owned by the state government. It exists to assist the setting up of industries, and one way it does so by lending to investors. The money it lends is public money, being the government's equity in the company.
you want to set up an industry.
Well, I have already set up a hotel.
Ask.
Now, there was a due. Well, I have already paid to an OTS. Now, it was a time.
Who is appearing for the state?
Lord,
You have sub.
yes, Mr. Shah apparently has been briefed.
Mr. Arnab Shah,
Mr. Shubir Shah. Lord,
learned counsel for the. We are disposing of the writ and the can. I mean, we just remand it to the.
Yes, great.
It is submitted by learned counsel for the appellant that that service has been effected on the state respondent. Full stop. On the prayer of learned counsel for the appellant, comma, leave is granted to the appellants to file the affidavit of service during the course of the day. Full stop. The matter is taken up for disposal on the short ground that the learned trial judge dismissed the writ petition only on the ground that no public law element was involved, comma, that too after the after pendency of about 12 years of the writ petition. Full stop. It is submitted by learned counsel for the appellants that the writ petition was filed in the year 2011 and was initially admitted, and affidavits were directed and exchanged. Full stop. An interim order was also passed. Are you sure interim order was passed, Mr.
Yes,
Dr.?
yes, page.
An interim order was also passed.
Page 91. Page
You're sure that's
91. They have
sufficient. You're
also filed
sure
a
that's sufficient. You are sure that's sufficient. An interim order was also passed therein. Full stop. Next para. It is contended that at this mature juncture, comma, the point of maintainability having never been taken at any previous juncture, comma, the writ petition ought not to have been dismissed on such technical ground. Full stop. That apart, comma, on merits, comma, it is submitted that there are public law elements involved. Full stop. Next para. We find from the records that the learned trial judge dismissed the writ petition at this stage of hearing only on the ground that no public law element was involved and the matter pertains to a private contract. Full stop. Apart from the fact that such objection was never taken or recorded at any point of time during the 12 years of pendency of the writ petition, comma, the writ petition was at the hearing stage, comma, affidavits having been exchanged by the parties. Full stop. As such, comma, it would tantamount to shirking the court's duty not to decide the same on merits. Full stop. That apart, comma, under the principle of Order 14, Rule 2 of the Code of Civil Procedure, comma, which in the absence of any contrary rider, comma, is also applicable to writ petitions on principle, comma, it was the duty of the learned single judge to decide all issues. Full stop. Next para. Moreover, comma, the question as to whether any public law element is involved is in the least arguable, comma, since the petitioner is a company, the petitioner number one is a company which has set up an industry, and the primary and the principal respondent is a body, is an authority which is an instrumentality of the state and is in charge of facilitating industry. Full stop. Next para. In such view of the matter, comma, we are of the opinion that the impugned order being cryptic and on a wrong presumption of law, comma, ought to be set aside. Accordingly, MAT 88 of 2022 as well as Can 2 of 2023 are allowed, comma, thereby setting aside the order
16th May 22.
order dated May 16, 12.
12th May 22.
Order dated May 12, 2022, passed in WPA 5913 of 2011 and remanding the matter back to the appropriate learned single judge for deciding the writ petition on merits.
Only one thing, interim order that was continuing page 91 since 6th May 2011 and vacating application was heard by my lord justice.
The interim order which had been initially granted in the writ petition stands revived as on this date and shall continue till the disposal of the writ petition.
Grateful, my lord. Grateful.
Inform the learned counsel for this state, please.
Grateful.
And file your affidavit of service during the course of the day.
Grateful. Grateful.
Thank you. 7.
I am appearing for the state at 2 p.m. yesterday night, my lord. I have to say, Mr. Biswas was appearing for the state, but
should he keep it in the next circuit?
No, my lord, kindly. He requested for a passover because of demise of his relative.
Oh, acha. Passover?
Obliged.
Passover we are making not today then. It will be answered.
As per his message, he said that he will be.
We are passing it over. If he comes and the other side is there, just mention to us. We'll take up.
Obliged.
Short Passover, PSG will appear in 8 and 9.
Passover. 8 and 9 দুটোই তো বললো।
Lordship, I'm praying for a short Passover.
No, no, not in every matter. Why?
My lord, item number 9, Lordship, Lordship, we are for the NCB, my Lordship.
You are for the NCB.
Yes,
You are
my
for
lord.
whom? Mr. Bishes is for whom? Item 9. 10.
Sorry, my lord. Sorry, my
9
lord.
has been
No,
passed over. 10
Lordship.
pass over.
Lordship.
You're appearing? Yes. Porter ready karo. Yes. Co-accused. Same footing. Same footing, Mr. Learned counsel for the petitioner contends that other co-accused persons standing on same footing as the petitioner have been released on bail in connection with the same offense. Full stop. On the hence, comma, on the ground of parity, comma, we are inclined to grant bail to the petitioner as well. Accordingly, CRM NDPS 727 of 2023 is allowed, thereby granting bail to the petitioner on condition that the petitioner furnishes bond of ₹10,000. Usual special court NDPS Jalpaiguri. Shall not leave territorial jurisdiction. এই আগের অর্ডারটা দেখে করে দিতে পারে একই।
Great.
Thanks. Yes. Yes. You are for the response. State. Yes. Ms. Shabata.
There is two petitioner before your lordship.
Hmm.
From them, recovery of 25 bottle of this cough syrup from them, respectively 25 bottles.
Hmm.
And their custody about 215 days. Charge sheet submitted. But in this case, seizure was made 18 February 2023, my lord. And inventory was made on 1st of March 2023.
18th
18th February search and seizure.
and 1st of March, right?
1st of March. There is delay about 15 days inventory, and this sample set for FSL on 18th of April 2023, my lord. There is also another delay for sending this sample.
215 days, you said.
Yes.
Custody.
Custody, 215 days.
Yes, what do you say?
Only
You're granting.
25 bottles, my lord.
Granted 25 bottles.
There are delays.
Thank you. Learned counsel for the petitioners points out that there was a delay in issuance of certificate of inventory regarding the samples and in sending the samples for FSL report. Because of that apart, comma, the petitioners are already in custody for 215 days and charge sheet has been submitted. Full stop. We do not find, comma, upon hearing learned counsel for the parties that there is any further reason for custodial trial of the petitioners. Full stop. Hence, comma, although learned counsel for the state opposes the prayer for bail, comma, we are inclined to grant bail. Accordingly, CRM NDPS 728 of 2023 is allowed. Satisfaction to the satisfactory special judge NDPS Shiliguri.
Yes.
Shiliguri. Bakita same.
Deep.
এখানে each of the ইয়ে হবে। So it is maybe common. Yes.
Sam for the petition.
Hmm.
I have a threefold submission. Well, it's my mother. She's a cancer patient,
Hmm.
and she's in the third stage. I have annexed the medical papers
Hmm.
with your lordship's briefs,
What else?
and I am the only male member of the family.
Hmm.
Secondly, if your lordship kindly sees FIR, kindly comes to page 32, paragraph number 3.
Hmm.
With regard to the seizure witnesses, lordship, the contraband articles have been seized from the oil tanker. 2 mechanics have been called by the investigating agency for the recovery of the contraband article. Subsequently, when the seizure was done, they have been put as a independent witness to the seizure, and to sign in the arrest memo.
You were the driver.
I was the driver. I was the driver.
Right.
My lords. And
So independent mechanics as witnesses. In mechanics as independent witnesses.
yes, Your Lordship. My lords, my contention is that it violates the section 41B as because they have been called by the police authorities to do something upon a payment of a consideration.
No, mechanics were traveling with you.
Mechanics have been, a police officer, the raiding party, they have sent a SI of police to the garage to bring the mechanics in the spot.
Why were the mechanics brought in the first place?
Car has been apprehended.
That is a technical ground you are
Well,
taking. That's an absolutely
well,
technical ground.
Second,
Lord, in order to dismantle.
No, peaceful argument. Let us hear them at length, then we'll hear it. On all the points, please argue. Yes, Ms. Shorka, be fast. What else? What else? Let us see the complete will be. হ্যাঁ ব্রাউন সুগার তো একদম
give me a minute, my lords.
You're not ready in the matter, Mr.
My
Shorka.
lords, my lords. Well, it's 6 lines from the bottom of this judgment, which has been passed by the Honorable Apex Court. For the transparency of the.
No, in your case, what is the occasion of calling the mechanics?
Well,
There is no mention of mechanic or anything here.
Well, it's there. It's there.
Show us that.
My lords, it's paragraph number 1 and 2 in page number 33. Paragraph number 1 and 2. Your
So
Lordship.
why were you showing the third paragraph of page 32? How is that relevant? Para 30, page 33, para 2 is relevant for your first submission.
And secondly, is your lordship, is that the STF has informed that the persons are being carrying the contraband articles. There was no gazetted officer, hence the raiding party, the FIR maker, de facto complainant, he informed the superior officer, hence the same of the officer from the same department has been sent for the search and seizure. Malats will seize the section 50, where it's categorically stated that it will be the provision of section 41, 42, and 43 will be looked into while the arrest will be done. Malats, in 41, 42, and 43, it has been specifically stated this central government, which departments should conduct the raid. And in respect of the state government, it has simply stated that the department which are supposed to be notified by the government, they can conduct the raid as per their notifications, the gazetted officer. In this case, the raiding party, the department who is supposed to be the raiding party, the STF, Special Task Force, entire procedure has been done by them. Well, I will be lead to the acquittal of this case on this particular ground that the person who has searched and made the seizure in his presence, he belongs to the same department.
Very well. Let us hear them. Yes.
My lord, as soon as, my lord, the offending.
How long are you in custody?
My lord, I am in custody for 213 days.
Yes.
Charge sheet has been.
Please continue. Yes.
My lord, as soon as, my lord, the offending vehicle was intercepted, my lord, it was suspected, my lord, the contraband article was hid in the tank, fuel tank. My lord, for that reason, my lord, two mechanics were called, and before my lord calling them, my lord, they were asked, my lord, to voluntarily put their signature as a witness. They agreed, my lord. Now, my lord, the two, my lord, mechanics were called, my lord. They dismantled, my lord, the fuel tank, and the contraband article were, my lord, recovered and seized. My lord, that is the. Now, my lord, with regard to, my lord, the 41B, my lord, this is, my lord, fully compliant. They are the independent witness, my lord. They are the inhabitant of the locality of that locality. Now, my lord, so far, my lord, the section, my lord, 55 is concerned, my lord. Kindly come to, my lord, section 53 of the NDPS Act.
Yes.
53. My lord, 53 subsection 2 states that, my lord, the state government may, by notification published in the official gazette, invest any officer of the Department of the Drug Control or Excise or any class of such officer with the power of any officer in charge of a police station for the investigation of the offence under this act. Now, my lord, section 50, subsection 5. But when an officer when an officer duly authorized under section 42 has reason to believe that it is not possible to take the person to be searched to the nearest gazetted officer or magistrate without the possibility of the person to be searched parting with the possession of any narcotic drug or psychotropic substance or controlled substance or article or document, he may, instead of taking such person to the nearest gazetted officer or magistrate, proceed to search the person as provided under section 100 of the Code of Criminal Procedure. Now, my lord, the notice under section 100 was, my lord, issued. But kindly have a look on the case diary.
For that, you have to have a something indicate some indication has to be there. It was not possible to take the person. Why it was not possible to take the person to the nearest gazetted officer?
No, my lord,
Nothing is there on the.
my lord, gazetted officer was called, my lord. The inspector.
Anyway, third stage of cancer and only male is a very.
That is may not be a ground, my lord. His mother is suffering from cancer, my lord. He is not a, my lord, patient, my lord. This is not a ground, my lord. But huge quantity of contraband article has been recovered, my lord.
But what is the use of custodial trial for the 212 days? He is already in custody. Charge sheet has been filed. What is the stage of trial?
Yesterday, my lord, was fixed for, my lord, framing of charge, my lord. 20 of, my lord, September. My lord,
How many witnesses are likely to be there?
My lord, there are, my lord.
16. 16.
16. But at least, my lord, charge be framed, my lord. He is a resident of Manipur, my lord. If he is enlarged on bail, my lord, he is never be catched.
No, there will be one local surety and he will be not. He will not be living without leave of. He will not go there.
If he is released on bail.
Manipur, if he survives Manipur after going back there, then definitely you can always catch it. He is a part of India still.
My lord, he is a permanent resident of Manipur, my lord.
So what? Manipur is not so far off.
My lord,
Where is there northeast?
My lord, it won't be possible, my lord.
No, that is not a good plan.
My lord, the charge is yet to be framed, my lord. Let me ascertain that whether.
That's your problem, institutional issue. Charge is not yet framed. When was the charge sheet filed? When was the charge sheet filed?
On 12th of August 2023.
12th of August 2023.
What were you doing so long? He was apprehended 212 days.
12th of August, my lord. Only, my lord, 18 days, my lord.
Why was it filed so late?
Within statutory period. Within statutory period. It was filed within statutory period. No procedural latches.
Your mother is in Manipur.
Yes, my lord.
What I suggest, because
you knew your mother is in such stage. Why did you commit this offense?
Well,
you're driving a car. There was a drug in there, very convenient, and that was in the fuel tank.
My humble submission before your lordship, that I will bring my mother here because North Bengal Medical College is very much prudent enough to give a proper treatment for cancer. Eventually, Siliguri is also having such institutions from where the patients have been curing. Your lordship knows very well.
It is a far-fetched ground.
I'm the only member. I'm the son. I have to take care of her.
Doubt which bail is the rule. Learned counsel for the petitioner argues primarily 3 points in support of the prayer for bail. First, the two mechanics who were called by the police themselves and signed as independent witnesses in the memo of arrest might not be classified as double inverted with the independent double inverted clause as such. Secondly, comma, the person who signed the seizure list in the capacity of gazetted officer was an official of the same department as the raiding team. Thirdly, comma, the petitioner's mother is suffering from cancer, which is at its third stage, and the petitioner is the only male member of the family. Next para, learned counsel for the state vehemently opposes the prayer for bail and submits that the charge sheet has recently been filed and the charges are due to be framed soon. That apart, comma, it is argued that the condition of the mother did not deteriorate overnight and the same was available when the petitioner was apprehended as well. Moreover, comma, the petitioner himself is not a cancer patient. Next para. Secondly, comma, it is argued that in view of section 50 within bracket 5 of the NDPS Act, comma, there is scope of persons other than an officer, than a gazetted officer or a magistrate to sign, comma, if he is duly authorized under section 42 of the said Act. Next para. Even otherwise, comma, it is argued that the two mechanics cannot be said to be said not to be independent witnesses. Next para. Insofar as the first ground is concerned, comma, although there is some doubt as to whether two persons called by the investigating team in a premeditated way as mechanics and who are part of the process of seizure can be called independent witnesses, comma, the nitty-gritties of such point need not be gone into at this stage, comma, since the same is a perfect subject matter of argument in trial. Insofar as the second ground is concerned as well, comma, section 50 within bracket 5 confers a discretion on the authorities to for a person duly authorized under section 42 of the NDPS Act to act instead of a gazetted officer or magistrate. However, comma, insofar as the circumstances stipulated in section 50 within bracket 5 is concerned, comma, we do not find anything on record to indicate as to why it was not possible for the search to be carried out under the aegis of the nearest gazetted officer or magistrate. Next para. Moreover, comma, the petitioner pleads to be the only male member and his mother is in the third stage of cancer. And since the petitioner seeks to have his mother treated in a good hospital in an renowned Siliguri, comma, we find that the same is a sufficient reason to grant bail to the petitioner on stringent conditions. It has to be kept in mind, comma, however, comma, that the respondents are apprehensive that the petitioner is a permanent resident of Manipur and may flee the jurisdiction of the court. Next para, keeping in regard the above considerations, comma, CRM NDPS 729 of 2023 is allowed, thereby granting bail to the petitioner on condition that the petitioner shall furnish bond of rupees 10,000 with two sureties of like amount each, one of whom must be local, to the satisfaction of... Yes.
With regard to, my lord, the inability, my lord, to call the gazetted officer, my lord, there was sufficient reason, my lord, narrated in the first information report. That why at that point of time, my lord, the
first information report is post facto.
My lord, it was
In the complaint, it is not there.
the inability.
If something is not there in the complaint, that finds place in the FIR, sir. And if that is a justification of your action, that palpably vitiates the process itself. We have not gone into that because we are not hearing the appeal. If something is not there in the complaint, that is in your favor, the investigating team's favor, and that has been introduced in the FIR for the first time, there is a disparity between the two, then it has to go, the presumption is against you. You are trying to justify your action. So let us not go into that. To the satisfaction of the learned judge, special court at Jalpaiguri, next para, the petitioner, comma, furthermore, comma, shall not leave the territorial jurisdiction. Usual যেগুলো থাকে সেগুলো থাকবে। Plus তার সঙ্গে আরেকটা add করে দিন। It is further to be noted that in the event the petitioner seeks to leave the territorial jurisdiction of the trial court during the period of trial, comma, the petitioner shall have to obtain leave from the trial court and shall be so permitted only for the limited purpose of attending his mother at Manipur or bringing his mother from Manipur to the territorial jurisdiction of the Siliguri court, comma, for the purpose of a treatment. Full stop. In such event, comma, it will be open to the trial court also to consider protective measures to ensure that the petitioner does not flee justice by going to Manipur.
Grateful.
Next. It was.
With regard to item number 14, kindly takes it at 2 p.m.
Let it be called. No, 2 p.m. fixes, and then we are passing it over. Not today. Not today. Yes.
Expect me to mention item number 7 when.
Both sides are there. Item number 7. Yes, 7 to call.
This is an application for.
Everything taken care of. The problem you had? You had
Yes, Lordship.
for the timing taken care of.
Yes.
Yes.
This is application for recall of your lordship's order by which my application for bail has been refused by your lordships. My lord, your lordships formed an opinion that since the order of extension was not challenged by myself, and in the intergenum charge sheet was filed, by filing of the charge sheet, my lord, my right to default bail has swept away. My lord,
No, you did not assail the order extending the period of detention.
yes, my lord.
Yes.
Sir.
Yes.
My lord, the small issue that arises for reconsideration, my lord, that whether my right to default bail will get wiped away by filing of charge sheet at a subsequent event of time.
That is a legal argument. That does not furnish any ground for recall.
Proposition, my lord.
Even if it's a settled proposition, that's a legal argument. That does not call for a recall of the order or this is in the nature of a review. Review scope is very limited. Error apparent on the, it's an arguable case. Yes.
Yes, my lord. My lord, I was taken by the element of surprise by Maharaja Singh's judgment, my lord. I had not gone through it.
No, we can appreciate that, but this does not furnish any reason for this recall. Recall is not available
My
to
lord,
you.
for one moment, my lord, kindly come to page 25, para number 13 in Uday Mohanlal Acharya. My lord, this issue has been settled, my lord.
Please read it out. Yes.
Para 13, my lord, I'm reading it out.
Yes.
In state of MP versus Rustam, my lord, in state of MP versus Rustam, kindly allow me to place.
Since Rustam we overlooked Rustam, it must be Chupa Rustam.
My lord, in the state.
Read the relevant portion. We are on recall. It's a very short matter.
Can you come to page 5 and 6 of Rustam, my lord, in the second compilation?
Duto copy this.
My lord, I am having only one.
Oh.
Para 5 and 6, my lord.
Para 5 and 6. Apni dekhun eta. Para 5.
My lord, in state of MP versus Rustam, it was held that by filing of charge sheet, the right to default bail gets extinguished. That was considered by the Honorable Apex Court in Uday Mohanlal Acharya and para 13, my lord, I'm reading it out. In state of MP versus Rustam, this court set aside the order of the High Court where the High Court has released the accused on bail, charge sheet not having been filed within the period stipulated under section 167(2) of the Code of Criminal Procedure, as by the time the High Court entertained the bail application, challan, that is charge sheet, my lord, had already been filed. This court has observed that the court is required to examine the availability of the right to compulsive bail on the basis on the compulsive bail on the date of its consideration, the question of bail, and not barely on the date of presentation of the petition of bail. This court came to the conclusion, SCC para 223, page 223, para 4. On the dates when the High Court entertained the petition for bail and granted it to the accused respondents, undeniably the challenge stood filed in the court. And then the right as such was not available. Now, my lord, kindly come to the subsequent part.
Right was never available. His right never accrued.
Yes, my right accrued, my lord.
He filed an application on 179th day. Accrual of right occurs after expiry of the prescribed statutory period.
My lord,
179th day.
That was a
has no
specific
right to
in
be
the,
released on default bail.
that was a specific case in Maharaj Singh also.
my lord, kindly appreciate. My lord, he
And subsequently,
interrupted, my
extension
lord.
orders were not
Last day
challenged.
also he interrupted.
He's again trying to interrupt so that he
Yes.
can.
My lord, kindly
He's in the
appreciate.
habit of interrupting.
Yes, my lord.
I'm a bad boy, I know.
My lord, on the 179th day, one application was filed. Then on the next page, that your lordship will find in page 27, just after, not this, my lord, in the original petition. Just after a lapse of 5 days, I again filed an application. That was my assertion of the right to default bail. My lord, kindly appreciate, my lord, the right to.
See, there are two aspects of the matter. One is that filing of charge sheet does not absolve.
Yes,
Take away your right.
Yes,
That is one aspect of the matter. The other aspect is extension was actually granted to them. They applied on the 179th day and it was granted.
Yes, my lord.
So if it was granted, where is the question of?
That is what, my lord, that was held by the 3 judges bench in Subhash Jadav's case.
It's an arguable question. Cannot be. This is not an error apparent on the face of it. Yes, now disturbed.
His lordship was the leading judge, was the leading member of the three judges bench.
My lord, kindly
Passed the order in Maharaja Singh.
kindly come to pages 83 and 84.
Justice Bakshi led the three judges bench and Maharaja Sinha subsequently passed by Justice Bakshi.
My lord, kindly come to
Not Maharaj Sinha. Maharaj Sinha was a different.
my lord, kindly come to pages 83 and 84. My lord,
No, this is an
very
arguable.
important. My lord, why I am saying so, my lord, because the Honorable Apex Court has held that once the right to default bail attains indefeasibility, it partakes the character of a fundamental right. Kindly come to pages 83 and 84.
Right.
Yes, 83 and 84 of your.
Yes, my lord, para 36 and 37. I am reading it out for your lordships, my lord. Para 36, a conceptus of the aforesaid decision should show that so long as the application for grant of default bail is made on the expiry of the period of 90 days, which the application need not even be in writing, before a charge sheet is filed, the right of default bail becomes complete. It is of no moment that the criminal court in question either does not dispose of such application before the charge sheet is filed or disposes such application wrongly before the charge sheet is filed. This is very important, my lord. Even if my application for default bail has been wrongly disposed of, so long as the application has been made for default bail on the expiry of the stated period before time is further extended by the maximum period of 180 days, default bail being indefeasible, right of the accused under proviso, under first proviso to section 167(2) kicks in and must be granted. And 37, para 37 is the most important, my lord. Last 7 lines. We must not forget that we are dealing with personal liberty of an accused under a statute which imposes drastic punishments. The right to default bail has been correctly held by the judgments of this court and not mere statutory rights under the first proviso of section 167(2) of the court, but is a part of the procedure established by law under Article 21 of the Constitution of India, which is therefore a fundamental right granted to the accused person to be released on bail once the conditions of the first proviso to section 167(2) are fulfilled. Well, my case is the same.
No.
Once the extension was granted solely on the basis of non-availability of the FSL report. Now, my lord, the 3 judges bench of this honorable court has clearly held that such extension could not have been granted. And thereafter, following Subhash Jadhav, my lord, in all of the cases where such extensions were granted, Because the accused were granted bail. Because consistently this honorable court has held that that extension which was granted solely on the ground of.
Here it was not a question of your not filing the application before the.
Yes, I have filed, madam.
It is not a question of that it was filed or not filed.
Yes.
Here the question is from the opposite perspective.
Yes,
They had filed an extension application on the 179th
Yes,
day.
madam. Well,
So if an application is filed and for actus curiae, I mean,
Yes.
the nominum gravity, that principle applies. Here, if the court keeps it pending, here it is not a question of your having applied before the charge sheet is filed. Undoubtedly, you applied before the charge sheet is filed. There is no doubt on that.
Yes.
But it is not a question of that. Here, they had applied for extension prior to the expiry.
Yes.
That point has not been decided here. You are looking at it from the other perspective.
Yes.
So this does not furnish a ground for review of our order.
Well, which is why I am submitting, my lord. Considering Subhash Yadav, my lord, time and again, and catena of judgments, this honorable court has held that in all the cases where extension were granted solely on the basis of non-availability of the FSL report, which was an institutional shortcoming, that cannot, deeming it to be.
You are rejecting your application, we are furnishing the reasons. Ashu, the petitioner seeks a review of the order.
Kindly grant us the liberty to file subsequent application agitating the grounds, my lord.
Whereby the prayer for bail of the petitioner was rejected with a order dated September 18. Uh, 2023. Push up, learned counsel for the petitioner places reliance on the judgment
That's from my lord, page 11. 2001, 5 SCC, 453. Uday Mohanlal Acharya versus State of Maharashtra.
judgment of Uday Mohanlal Acharya citation to দিয়ে দেবেন in support of the proposition that if the application for default bail is filed at a juncture when the charge sheet had not yet been filed, comma, the same is sufficient to create an indefeasible, INDEFEASIBLE, indefeasible right in favor of the accused to get default bail. Full stop. Learned counsel places particular reliance on paragraphs 36 to 38.
That is of Vikramjit Singh.
36
State
to
of Punjab, 2020, 10 SCC.
38 of Vikramjit Singh versus State of Punjab reported at 20.
2020, 10 SCC, 660.
লিখেছেন 10 2020 10 SCC 616 আমি শুনতে পাচ্ছি আপনি শুনতে পাচ্ছেন 16 full stop. It is contended that the Supreme Court categorically held that so long as an application for grant of default bail is made on expiry of the period of 90 days before a charge sheet is filed, comma, the right to default bail becomes complete. Full stop. Next para. We find from the learned counsel for the state opposes the prayer of review. Full stop. Next para. Upon hearing learned counsel, comma, we find that the proposition laid down in the judgment cited by the petitioner was that the right to get default bail ripens the moment an application is filed by a petitioner or even an oral prayer is made after the period of 90 days, comma, prior to filing of charge sheet. Full stop. Subsequent filing of charge sheet cannot defeat such right. Full stop. Next para. The question in the present case is to be looked into from the opposite perspective, comma, in view of the order under review having been passed on such premise. Full stop. The question in the present case is not whether the petitioner applied for default bail in time, comma, which has not been disputed by the court while passing the order under review. Full stop. The issue which arises is whether the prosecution had filed an application for extension of time within due time. Full stop. Next para. Since the application for extension had been filed by the prosecution on the 179th day, comma, it cannot be said that the extension application was delayed. Full stop. Next para. If an application for extension of time is not decided in due time, comma, the same tantamounts not to a fault of the applicant, but of the court, comma, amounting to invocation of the doctrine of actus curiae minimum gravabit. Full stop. এটা যদি না বুঝতে পারেন, actus ACTUS curiae QURIAE minimum NEM gravabit GRAVABIT, and as such, comma, it has to be deemed that the date of filing of the application for extension is the date on which such extension is granted. Full stop. Next para. Hence, comma, although no fault could be attributed to the present petitioner for not having filed the application for default bail in time, comma, in the same breath, comma, the authorities had applied for extension of the time which was subsequently granted. Full stop. Next para. Although learned counsel seeks to cast aspersion on such extension on the ground that the same was not permissible in law, comma, since the extension was sought for the non-filing of FSL report, which is an institutional fault, comma, the petitioner failed to challenge the extension of time on such ground or otherwise before any forum of law. Full stop. Hence, comma, the extension having attained finality, comma, the petitioner cannot now say that the petitioner is entitled to default bail. Full stop. Hence, comma, looked at from such perspective, comma, the arguments advanced by the petitioner are not acceptable. Full stop. Next para. Even giving the best option to the petitioner, comma, the case sought to be made out now is arguable and at best pertains to an alleged error of law which cannot be entertained as a ground for an application for recall stroke review after the order is passed. Full stop. Accordingly, CRAN 1 of 2023 is dismissed. Full stop. However, comma, it is made clear that nothing in this order shall prevent the petitioner from making a subsequent application for bail, comma, if the petitioner is so entitled in law otherwise.
Grateful.
বেল শুনতে গিয়ে অ্যাপিলেট হিয়ারিং হয়ে যাচ্ছে, অ্যাপিলেট ইচ্ছে তাড়াতাড়ি হয়ে যাচ্ছে, আর্গুমেন্টস অফ ল হলে কি করে? তাকো তুমি আগেরটা দিয়ে নিয়ে তারপর পরেরটা, আগেরটা গুছাবে পরে, আগে পরেরটা দিয়ে নাও। Yes.
I am for the step.
Yes.
4 kg, 812 gram of brown sugar, my lord. And she is the kingpin. My lord, there were another FIR also, my lord.
Where do you get that she's the kingpin? She was arrested before in many cases.
Yes, my lord. Naxalbari PS case.
That does not mean the per se that she's a kingpin. Kingpin is something else who runs the racket.
Yes, my lord.
Habitual offender. This is
One
habitual.
statement is there, my lord. Of my lord, once it was statement and the co-accused stated that he asked for the four and that.
How long is she in custody?
My lord, the FIR 16th August 2023, 61 days, my lord. She has not submitted.
She has not submitted it.
No, my lord.
No, this is premature, Mr.
4 kg of brown sugar, my lord.
We are appreciating even without your shouting, Mr. Sir. We are appreciating even without your shouting.
When statement of coercion, any person implicated. In such case, person enlarged anticipated. I rely on some judgment. In such cases, who judgment, statement of coercion is not available to the business. Bail is because anticipated bail granted. Many cases.
Yes, yes. Yes, many cases. We know we have also granted.
Yes. In this case, I specifically we have 3 children. She indicated you can use police personnel. Only in the statement of coercion. I taken into custody. There is a 5 days police demand. Nothing was recovered during the police custody period of remand. What remained? There is no possibility of further recovery. 2.5 years old boy. Any stringent condition, statement of coercion, 5 days police custody taken, nothing was recovered. In such a situation, petitioner was granted anticipated bail. I have been bail. I have suffered custody for some period. Being a lady, 3 children, any stringent condition, This is my respectful submission,
Learned counsel for the petitioner argues that the petitioner is a lady having 3 children, one of whom is only 2.5 years old. First up, it is submitted that there is no other responsible female member to look after her children. So that apart, the petitioner was arrested on the basis of statements of co-accused persons, which is not a valid ground for indicting a person. So learned counsel cites several judgments of coordinate benches where anticipatory bail was granted to the accused person on the ground that he or she was indicted on the basis of statement of co-accused persons. Next para. Learned counsel for the state opposes the prayer for bail. Full stop. Learned counsel places reliance on the FIR and argues that the quantity of brown sugar seized was of a huge amount, being about 4 kg 812 grams. Full stop. That apart, the accused person was arrested before in many cases at Khoribari PS and Naxalbari PS in similar cases, copies of FIRs of which were enclosed in the CD. It is further argued that the petitioner is one of the kingpins involved in the racket of narcotics. Next para. We find upon hearing learned counsel for the parties that the petitioner is in custody for about 61 days and the charge sheet has not yet been filed. Despite the fact that the petitioner has a 2.5-year-old child and 2 other children, we are of the opinion that since one of the daughters of the petitioner is 17-year-old, the situation of the petitioner is not such that the 2.5-year-old child of the petitioner, being one of the siblings of the eldest daughter, is without any care. Moreover, the petitioner is in custody only for 61 days and the charge sheet has not yet been filed. Since the petitioner was arrested in other cases on similar grounds, we are not confident that the presumption under section 37 of the NDPS Act can be mitigated in the present case. Hence, we are not inclined to grant bail at this stage to the petitioner. Accordingly, CRM NDPS 731 of 2023 is dismissed. FIR is not statement of co-accused. Previous statements, those have been enclosed. Next. ডেকে না বললাম না তোমার পরেরটা ডেকে ফাইলটা দিয়ে তারপর এগুলো না গুছানো করে এই সময়টা যে শুনছি তখন ওগুলো করে নাও।
This case, 307 gram brown sugar was recovered from the 3 person worship. One of them petitioner in this case worship. In the FIR worship, they specifically mentioned that 3 persons possession of huge quantity of brown sugar in their position coming in a auto from NGP to Shalwar. But worship, the GDNT, which was written and the information which was sent to the IC is totally different. There are the 3 persons standing with the auto at Pisimittal bus stand with huge quantity of brown sugar. That place is Pisimittal bus stand and it is minimum 10 kilometer distance worship. And there is nowhere mentioned from where the brown sugar was recovered, from whose position or from the what, or from any bag, from who, not mentioned. And moreover, Lordship,
No, the discrepancy is between the between what the and
the GD, the information sent to the IC Lordship. And Lordship, moreover, Lordship, in this case, the sample which was sent, Lordship, the weight is 3.32 grams. Lordship, the rule, Lordship, which was in 2022, the rules may be called as the narcotic drugs and psychotropic substance, seizure, storage, sample, and disposal rules, Lordship. Lordship, page number 21, Lordship.
what is the rule? Just tell us.
The quantity to be drawn for sampling. Lordship, there is that except in cases of opium, gaja, and choros, where the quantity of not less than 24 grams shall be drawn from the each of sample. In all other cases, not less than 5 grams. Lordship, this is the mandatory provision, Lordship.
Yes, what do you say, Mr. Ganguly?
Lordship, what is there in the rule is rule. That is, this is heroin, brown sugar. That is the
And what about the discrepancy in the place of arrest?
Lordship. Not place of arrest, Lordship. After receiving the information, when the GD was made, it was made that they have the information that some persons are coming from NGP in a auto. But in the FIR, when it was mentioned that when they went to the PC Mittal bus stand, the 3 persons was sitting in the auto. So the auto might come from NGP and stand in the bus stand. So that's not much discrepancy, Lordship. Here, as per the rule, Lordship, here brown sugar was seized. Now,
It was much less than the sample to be sent by the rules.
Yes, Lordship, but the sample was found positive as per the report of the FSM.
How long in custody?
More than 7 months.
Charge sheet have
Yes, the charge is submitted.
in the present case, the charge sheet has been submitted and trial has begun.
No, Lordship. Only 7 months.
Charge sheet has been submitted. Full stop. The petitioner is in custody for 7 months. Stop. The petitioner has raised a question regarding the process of seizure and search and arrest on 2 grounds primarily. So first, there is alleged discrepancy between the petitioners, discrepancy between the FIR and the GD entry which was sent to the IC, insofar as the petitioner and the other co-accused have been described to be coming in an auto rickshaw in one and in the other to have been apprehended at a particular bus stand, where they were allegedly standing. Second, allegedly stationary, standing stationary. Full stop. Next para. Secondly, it is argued that the quantity sent for quantity of the sample sent for examination was much below the quantity which is required to be sent as per the extant rules. Next para, learned counsel for the state opposes the prayer for bail and argues that the alleged discrepancy is minor and is only a matter of description. Full stop. It is further argued that whatever may be the sample sent, the same turned out to be positive. Full stop. Next para. We are of the opinion, upon hearing learned counsel, that sufficient cloud has been cast on the restriction under section 37 of the NDPS Act in view of the sample having been sent for examination being much less than the quantity which is required to be sent as per the governing rules. Full stop. Moreover, the petitioner is already in custody for 7 months and we do not find any requirement for custodial trial, particularly since the charge sheet has already been filed. Full stop. Accordingly, CRN NDPS 732 of 2023 is allowed, thereby granting bail to the petitioner on usual condition, to the satisfaction of Judge Special Court at Jalpaiguri.
Grateful, Lordship.
Thank you. Special Court NDPS Act, Jalpaiguri. Thank you. Yes, sir. No, city tomorrow. Not today. Yes. Yes.
18, my lord, I am for the petition.
Yes.
My lord, this is an application for bail, my lord, arising out of charges under the NDPS Act. My lord, in the complaint, my lord.
Only 70 kg.
No, my lord.
Gaja, 70 kg, 400 grams.
Yes, Rajesh. 1 year and 7 months, 15 days in custody. My lord will find that in the complaint, they have stated, my lord, that there was no independent witness. The police party has witnessed the seizure. And my lord, in the in the memo of arrest, my lord, they have somewhere, my lord, brought one person, my lord, and they have got a signature of that person who has not witnessed the seizure. My lord, this is totally contrary to the statements, my lord, they have made in the FIR. In the charge sheet also, my lord, that person's name does not transfer as a witness. My lord, moreover, most surprisingly, my lord, this sample was sent to one botanical survey of India, my lord, which is not a designated lab under the NDPS Act. My lord, the botanical survey of India is, my lord, is for a totally different thing under the Ministry of Environment and Climate Change. For botanical, my lord, for studies and everything.
Gaja improves the environment after you take it. So maybe something environmental element is there.
No, my lord, I have.
Anyway, yes. Yes, what do you say to this botanical survey and all these things? What are you doing?
That is the matter of trial.
Not trial. This is a matter of error, not trial. Learned counsel for the petitioner has made out 2 concrete grounds for grant of bail, since suspicion is cast on the presumption under suspicion is cast on the process of arrest and seizure, which does not give rise to the restrictions under section 37 of the NDPS Act. First, although it was mentioned in the complaint that there is no independent witness, a person signed as an independent witness in the memo of arrest, but was neither mentioned in the charge sheet nor has been sought to be produced as a witness. Next para. Secondly, the samples were sent to one, apparently sent to one botanical survey of India, which is not what is it called? It's approved.
Designated lab.
Not a designated, right? Not a designated laboratory for conducting such tests. Next para. Learned counsel for the state opposes the prayer for bail. However, in view of the alleviating circumstances mentioned above, NDPS CRM NDPS 735 of 2023 is allowed, granting bail to the petitioners on condition usual to যেহেতু দুজন আছে ওই 2 sureties of like amount each, one of whom must be local to the satisfaction 10,000. One of whom must be local, or sureties may be common for both the petitioners. To the satisfaction of which court, Mr. Chaudhary?
First court, additional session judge, first court, Kuch Bihar NDPS.
Special court NDPS, Kuch Bihar?
Yes.
Kuch Bihar.
Grateful.
Thank you.
19.
Yes, Mr. Mishra, what is the matter?
I'm for the petitioner, my lord. I'm in custody for 3 years, 2 months and 3 days as on today. I'm renewing my bail period, my lords. It was last rejected on 29th November 2022, which is more than 9 months and 19 days, my lords. In this case, my lords, the column 10 has been left blank. There is no independent witnesses. There were allegations against 14 accused persons, but only one has been arraigned, and the charge sheet has been filed against only one accused person, my lords. The 13 had been given a go away. Lords, the cognizance was taken based upon a charge sheet without FSL.
14 FIR.
14 were named in the FIR. That a group of 14 people are engaged in the business, but only one has been arraigned as an accused, my lord.
Right.
And the nil seizure list was not done in the presence of a gazetted officer, my lord. Those are my grounds.
Yes, what do you say?
For 3 years, 2 months.
Regarding memo of arrest, column 10 has been completed. As per the yes, it has been completed.
Gazetted officer?
No.
This was yes, no?
Page 20 for a moment, my lord. No, my lord, it hasn't been complied. Page 20, my lord. No independent witness.
Actually, previous, what happened in this case, the BSF personnel, they first,
Apprehended.
they have apprehended this person with huge quantity of ganja, about 50 kilos and 949 bottles of cough syrup. It's a cross-border matter, the smuggling was going on, matter.
So you're granting bail. Learned counsel for the petitioner points out that out of the 14 persons mentioned as accused in the FIR, only the petitioner has been named in the charge sheet, and the other 13 have been left scot-free. Further, it is contended that column 10 of the memo of arrest was left blank. Further, it is argued that no gazetted officer was present in the at the time of seizure. Thirdly, the petitioner is already in custody for 3 years, 2 months, and
3 days.
And 3 days. Next para. Learned counsel for the state opposes the prayer for bail. However, in view of the learned counsel for the state opposes the prayer for bail and further submits that out of 13 witnesses,
14.
out of 14 witnesses, 12 have already been examined and the trial is on the verge of completion. Next para. Be that as it may, since sufficient grounds have been made out by the petitioner, cast doubt on the process of seizure and arrest, and keeping in view the period of incarceration of the petitioner, we are inclined to grant bail. So accordingly, CRM NDPS 736 allowed granting bail to the petitioner. It has satisfaction to the special court NDPS Kuchbihar. Bakita same 10,000, 2 sureties like amount each.
I'm different.
Thank
Lordship, I'm for the state, Lordship.
I'm for the state.
Lordship, 2 co-accused already granted bail, Lordship, by this honorable court, Lordship.
After 1st of March.
Yes, Lordship.
By us.
Yes, Lordship. And the 2
18
accused,
September.
same footing, Lordship, 41 P non-compliance.
We are bound by our own order. Learned counsel for the petitioner submits that other co-accused persons on similar footing have been enlarged on bail. Next, learned counsel for the state opposes the prayer for bail and points out that on March 1, 2023, the previous application for bail of the petitioner had been refused by a coordinate bench. Next para, we find from the server copies of orders handed over by learned counsel for the petitioner that on September 18, 2023, that is about 6 months after the previous refusal of bail to the petitioner, other co-accused on similar footing have been enlarged on bail, accordingly, extending the benefit of Article 14 of the Constitution of India, we are inclined to grant bail to the petitioner as well. Hence, CRM NDPS 738 of 2023 is allowed granting bail to the petitioner. Similar conditions, satisfaction of special court NDPS Siliguri. 10,000, 2 sureties like amount each, satisfaction bollam jeta, shall not leave territorial jurisdiction trial court, attend trial each day. I shall not make an inducement.
I'm for the petitioner. Charges are under section 21C. I'm in custody since 4th May 2023. 4 persons were apprehended in a car, my lords. 1 is before my lords. My primary ground before my lords is that the sampling was done at the spot of occurrence, my lords. I will show you page number 15 to 16 of page number 16 of my application, my lords. The second last paragraph you will find.
Charge sheet has been filed.
No, my lords. My lords, I'll show you the rules as well. I have authorities with me, my lords. And in the seizure list, my lords, page number 26. Item number 1 and 2 in the description of seized article, my lords. My lords, kindly take section 52 50.
No, sampling was done at the time, at the
Place of occurrence, my lords.
where do we find that? Page 15 shows the relevant portion.
Page 16, my lord, second last paragraph.
Second last paragraph, yes.
I accordingly
Acha,
weighed
right.
the recovered said brown sugar
Yes, yes.
said to be
Section
from
50
which taken 10 grams. Yes.
Section 50.
52A, subsection 2, clause C, my lords.
Section 52A.
Subsection 2, clause C, my lords.
Yes, please.
Where any narcotic drug, psychotropic substance, controlled substance or conveyance has been seized and forwarded to the OC of the nearest police station or to the officer in charge in the section 53, the officer referred to in subsection 1 shall prepare.
Right, it has to be in the presence of a magistrate.
Yes, my lords.
It was not done here.
Yes, my lords. And
Yes.
there was a conflict in standing order 1 of 89 and 52AC, my lords, which came before the Supreme Court in Mohanlal. I'd like to place that.
The conflict was regarding this sampling.
Paragraph 12, my lords.
Doesn't the act prevail?
Yes, my lords. And there was
Act has to prevail in any event.
pursuant to Mohanlal, my lords, there was rules also framed. In the rules also, there is a specific rule I'll place.
I don't think Mr. Ganguly will, oppose the law on that. I mean, on other grounds, he will oppose the prayer for bail, definitely. Let us hear him. Yes.
Lordship, previously, the police authorities used to prepare sample at the place, and subsequently, when the law has been changed, it is the sample has to be done before the magistrate. Here, at first, following the practice, they have made sample, but the samples actually were prepared in the chamber of the magistrate. This is a court's order. But the sample was done. Certificate of inventory.
No, the first sampling was done at the spot.
That's irrelevant because the sample which was sent was done in presence of magistrate.
So that sampling was duly done.
Yes, but the order sheet says so. This certificate of inventory.
And the one sent was this sample.
Milords, may I submit, Milords?
No, wait.
Additional making of sample. How they are sending.
Superfluous.
Last paragraph. Sampling is there. Photographs. Sampling.
Yes.
So additional sampling is done. How can there prejudice?
This was for other purposes. The first sampling.
It's a practice, Lordship. They have
It was to just check up whether it was actually brown sugar or not.
They have to test kits, Lordship.
Taste, yes.
May I submit, Milords? Milords, in Mohanlal, it was categorically held that the sampling cannot be done at the place of occurrence, Milords. And pursuant, and the central government was also given a direction in Mohanlal to re-examine this issue. As a result, Milords, the rules was issued in 2022. Milords, kindly see paragraph number 15, 16, 17, 18, and 19, Milords, of Mohanlal. May I read, Milords? Section 52A1 of the NDPS Act empowers the central government to prescribe a notification, the procedure to be followed for seizure, storage, and disposal of drugs and psychotropic substance. The central government has an exercise of that power issued standing order 1 of 89, which prescribes the procedure to be followed.
See, sampling at that point of time, at the spot, that is not sacrosanct. That sample cannot be used for any purpose.
Yes,
that does not mean that they cannot take sample subsequently before a magistrate and do the.
Sampling is not allowed, Milords, as per Mohanlal, Milords. Categorically, they have said in Mohanlal
that is not allowed, undoubtedly, but that is not allowed for the purpose of indicting this person. That cannot be used as an incriminating material against them. That has not been used. It has been taken, sample has been taken.
But Milords, when a statute prescribes the method for doing a thing, it has to be done in
You're in custody for how long, you said?
140 days, Milords, and I'm a single mother. I have
That sheet has been filed.
no, Milords, it's not been filed. I have other grounds as well.
Not only this petitioner, Lordship, his husband, along with 2 drivers, they went to a certain place.
The husband is also under arrest.
He is under arrest.
But husband is not before my lords. Nothing was recovered from my body, my lords. And
you have a child of how many years? 18.
2 childs, my lord. 2 child, 7 and 16, my lords, as per my instruction, my lords.
Which is 7.
They must be habituated to this if you deal with drugs.
My lords, there's
almost 1
my lords, kindly consider.
Not in every case, no. They're not suckling babies.
My lords, consider one recent judgment of the Supreme Court passed
You cannot cite judgments in reply. You should have cited that at the time inception. Yes, what is this?
Similar, relying on.
What is the proposition here? Mohanlal, we are not disputing. We will not dispute in our order. We are accepting Mohanlal.
On the basis of
Lordship,
that,
if those, one second, Lordship. If I may permit it to, if those samples were sent without inventory, the question would be something else.
The most important question is what happened to those samples which were tested there?
Lordship,
And what happened to the raiding party after testing them?
Mother.
Learned counsel for the petitioner argues that the procedure of seizure itself is vitiated, since sampling was done at the spot, even as per the complaint and FIR. Next para. Learned counsel places reliance on Union of India versus Mohanlal and another, reported at 2016 1 SCC, 2016 3 SCC 379. In support of his contentions. Next para. It is further argued that the ratio laid down in Mohanlal has been followed subsequently in several cases. It is further argued that the petitioner is a lady and has two children who are approximately aged 7 and 9 years respectively. Next para. Learned counsel for the state opposes the prayer and submits that charge sheet has not yet been filed and it would not be appropriate to release the petitioner on bail, in view of the restrictions under section 37 of the NDPS Act. That apart, learned counsel places reliance on the case diary to show that the sampling was actually carried out before a magistrate and proper inventorization done. The superfluous sampling at the spot, it is argued, does not weigh, WEIGH, weigh in the circumstances of the case. We find from the records that the state is justified in arguing that proper sampling was done before the magistrate and a certificate of inventory was made. The state is justified in arguing that superfluous sampling at the spot ipso facto does not vitiate the process of trial. The proposition laid down in Mohanlal's case and other judgments following the same is that sampling done at the spot in the absence of a magistrate is vitiated and cannot per se be used to incriminate a person. Next para. However, even leaving aside the sample which was taken at the spot, there is sufficient compliance of the law and the rules inasmuch as subsequently sampling was done in presence of the magistrate and inventorization was duly certified. Hence, on such ground, we are not inclined to accept the prayer of the petitioner. Insofar as the petitioner being the mother of two children is concerned, we do not find that the children of the petitioner, even as per the prayer of the petitioner, are suckling babies and, as such, keeping in view the presumption under section 37 of the NDPS Act, we are not inclined to grant bail. Accordingly, CRM NDPS 739 of 2023 is dismissed. Sorry. At this stage, we are not inclined to grant at this stage. Come back in 10 minutes. Yes.
So pass over, learning is representing both.
Item 8 and 9 probably both.
Yeah.
Let us take up 8. Yes.
My lords, I wish to be excused because I got held up before, virtually before the Honorable Sekhi might.
No, no, absolutely. Yes.
Could not present myself.
No, no, sir. Yes. Yes. Yes, Mr. Habudar.
Application of bill, my lord, and if your lordship can you see the complaint, page 9. P1, my lord.
Ground of urgency was Shraddh ceremony.
Yes, well, I have the card, my lord, and also.
Other grounds.
Point I have.
Yes, definitely. Yes.
Otherwise, my lord,
The bail will also suffer a Shraddha. Page?
Page 9 of my application.
Yes.
Page 9 of my application, my lord.
9.
Yes, my page 9. Can compare first paragraph, my lord. It was seized, my lord, at the house premises of one Vishwajit Sarkar, my lord. And another, and second paragraph also, my lord, says, contraband was recovered from the house premises of Vishwajit Sarkar. Yes, my lord.
Yes.
Another point, my lord.
You are in the house of Vishwajit. That is the allegation.
There are other points, my lord. Can I take 5 minutes, my lord? Please, my lordship, can I see, page 15. See there.
Yes. 15.
Caesar, Earth comes Caesar.
Yes.
House premises of Vishwajit Sarkar. And next column, Earth started 2020 hours on 7th April 2023 and completed on 5:30 hours on 7th April 2023. So started and completed. This is the time. If your lordship kindly peruse arrest memo, last before the certificate copy, page 21. Second paragraph. On 7th April 2023, at about 18:20 hours at the office of 19 BSF, such and such, I was arrested. Search was completed at 5:30 and evening, it is 18:20 hours. I was arrested. Place of arrest, BSF camp. And the arrest memo, there is no respectable member, no independent witness. When search and seizure was completed, was arrested. I am the one of the family member of the Vishwajit. I brought before the BSF camp. I implicated in the instant cause. There is no compliance regarding 41B. And when
BSF apparently BSF does not know the law. In most of the memorandum of arrest, we are finding this in BSF. Mr. Mojumdar, you have to talk with your client. I mean, otherwise they may be actually culprits, but they will go scot-free. I'll come to you on merits. I'll come. Yes. Yes, we have got that point. Don't repeat the same point. Yes.
Section 41 clearly specifies
that
and there
specifies what?
At the time of arrest, either any family member.
Oh, those aspects. Yes. Right.
How in the written compilation from the house it
I
was
don't think
arrested.
41 says.
What else?
From the house.
Don't repeat. Yes, you have argued several times there.
Another thing, my lord, in the written complaint, it was said that, my lord, one Papu Mena, page 16, my lord. Papu Mena, assistant commander of BSF, who was the member of the raiding team, act as a gazetted officer, my lord. My lord, member of the raiding team.
Right.
Cannot be act as a gazetted, must be an independent. Police personnel as a gazetted officer must not be a member of the raiding. Must be independent person, my lord. Police personnel, section 50. Here, has from section 50, my lord. If you also calculate the one coordinate bench judgment, my lord.
For what purpose? Raiding.
Member of the raiding team.
Obviously, yes.
Cannot be a part of the gazette.
Right.
Well, this is threefold my submission, my lord.
Yes, what do you say?
Violation of section 41B. Section 50, my lord, is the member of the rating clearly admitted. It cannot be, my lord.
And time gap.
And time gap, my lord. And another thing is that I am the family member from the house of Vishwajit, not me, my lord. Recover.
That may be.
Yes, my hold of argument, my lord.
Very.
One time I.
Yes, Mr. Majumdar.
Lordship, within 180 days is.
I am 60 here.
180 days?
180 days is not over.
Even then,
My lord, it is temporary period.
why was he arrested at 6 p.m. in the evening?
The time of arrest, we cannot regulate. We will have to go by the prompt of the circumstances.
Who will regulate, Mr. Majumdar? They'll come themselves and come say arrest us.
Get the information. The picture that has always been drawn that we are demons, we are not that manner. We also.
Always we are not devils. Always we are not devils. Definitely.
We get the information.
Yes,
First of all, my lord, NCB does not operate in Siliguri, they sit in Calcutta.
that's true.
Obviously, we do not have any particular enmity against Shahabuddin's client to frame him. We do not know.
So at that point of time, you did not know he would be client of Mr. Shahabuddin. If you knew, maybe you would be more apprehensive. So Mr. Shahabuddin is not important. Yes, maybe you would be more apprehensive. Yes.
No, my lord.
These questions will be asked.
My lord, 475 kg ganjas were recovered. That is commercial quantity. My lord, once that huge quantity of narcotics is recovered, we have to look to section 37(1)(b). My lord, I will place a judgment of the Honorable Apex Court where no possession was found from the accused, yet bail was refused. So obviously 50, 41 all bails because it is not to be understood their lordship of the Apex Court were unaware of this situation of position of law.
No, they are also aware of 142. Article 142.
Yes, my lord, everything. Yet their lordship said even without possession being found with the accused, under 37(1)(b) bail cannot be granted during trial. My lord, if my learned friend had heart on the ground of Shraddh ceremony, I would have considered the penalty.
But there is a violation of section 50. I like this judgment.
Yes.
Recently passed by your coordinator bench.
Anything else, Mr. Majumdar? Mr. Shahabuddin, you forgot you are not arguing. Mr. Majumdar is arguing. Yes.
On the earlier occasion, my lord recalls, I had cited several judgments. The 50 what? The house inmates were informed, my lord. First bar is, my lord, he is within the statutory period. Then you argue, please.
So let us pass our judgment. Yes. The petitioner.
My lord, he was also earlier booked for dealing in illicit liquor.
It is now diversified. So let us encourage diversification of business.
I have to bring before you, my lord, his criminal background because
antecedents.
Yes, my lord. The two end conditions of 37(1)(b) says we have to believe that he has not committed the offense. That is not available at this point of time, and he will not commit offense if he is on bail. He has got criminal antecedents. And the Honorable Supreme Court in Ramanur said that they will always indulge in this clandestine. One of the case is Dinata case number 444 of 2021. Before this case was instituted. Under section 46 Bengal Excise Act.
The petitioner argues that the petitioners whose Shraddh ceremony? Petitioner's father's Shraddh ceremony is due to be held on September 23, 2023. That apart, it is argued that the person who signed as a gazetted officer at the time of seizure was a part of the raiding team, which violates section 50 of the NDPS Act. Next para. Moreover, the provisions of section 41 capital B of the Criminal Procedure Code was violated as the memo of arrest does not find mention of any independent witness. Thirdly, although the seizure was allegedly carried out in the wee hours, wee hours of the morning, the petitioner was allegedly arrested at around 6:20 p.m. Next para, such huge time gap, it is submitted, vitiates the presumption under section 37 of the NDPS Act. Next para. Learned senior counsel appearing for the NCB contents opposes the prayer for bail and contends that the statutory period of 180 days is not yet over. Full stop. That apart, comma.
His client was given, served a notice under 67 to appear.
Can you see the complaint, my lord?
Baba notice, what?
It is further argued that the petitioner was given a notice under section 67.
At the time, at the house, my lord. Can you see the complaint for me?
Full stop. Next para. Learned senior counsel next argues that the presumption of section 41 capital B of the Criminal Procedure Code are not applicable per se to an arrest and seizure under the NDPS Act. Full stop. Next para. It is further argued that the petitioner has criminal antecedents as other criminal cases are pending against the petitioner, comma, for possession of illicit liquor.
No conviction.
Of illicit liquor. Full stop. Next para. Upon considering the submissions of the parties, comma, we find that sufficient doubt is cast on the process of seizure and arrest. Full stop. First, comma, the provisions of section 50 of the NDPS Act are prima facie appear to have been violated, comma, since the gazetted officer concerned was a part of the raiding team.
We are getting confused, my lord. He was arrested after 67 notice was served upon him.
No.
That makes a difference, my lord.
Why do you say that?
But all the 3 persons are arrested.
No.
He came under 67.
No.
But no.
What? My lord,
There is a document that you say no.
my lord, please give an opportunity. My lord, can you see the page 10, my lord, of my appeal? Written complaint, ask my lord. Page 10, my lord. I show your lordship, my lord. Page 9 and 10, my lord. My lord, page 9 and 10. My lord, all the accused persons arrested on 1820, 1810, and 18.
He was brought under 67C. Question him.
My lord, can you see?
Examine any person according to the facts and circumstances of the case. And then thereafter he was arrested. So there will be a discrepancy.
Can you see page 18 also, my lord? Can you given some time? Opportunity. Can you see page 18, my lord?
What's up? Next para. Despite learned senior counsel appearing for the NCB being justified in submitting that since a notice under section 67 of the NDPS Act was allegedly served on the petitioner, comma, the question of contravention of section 50 of the NDPS Act does not arise, comma, even on other aspects, comma, we find sufficient doubt in the process of arrest, full stop. It is arguable, comma, to say the least, whether the provisions of section 41 capital B of the Criminal Procedure Code are applicable, comma, since there is no conflicting provision to section 41 capital B in the NDPS Act, comma, for holding that the latter act prevails over the CRPC in the particular context. Full stop. The memo of arrest, the memo of arrest clearly shows that there was no independent witness. Full stop. Moreover, comma, the process in which the arrest was carried out, comma, even if after notice to examination was issued under section 67 of the NDPS Act, comma, is suspect, comma, insofar as it remains unexplained as to why the petitioner was not arrested at the locale where the seizure was effected. Full stop. Next para. Moreover, we also keep in mind that the petitioner's father's Shraddh ceremony is being due to held on coming Sunday, that is September 23, coming Saturday, that is September 23, 2023. Full stop. Keeping in view the above observations, we are inclined to observe that the exceptions under section 37 of the NDPS Act, as enumerated in subsection 1 within bracket small b within bracket Roman 2 are applicable to the present case, for the purpose of granting bail to the petitioner. Full stop. Next para. Hence, we are inclined to grant bail. Accordingly, CRM NDPS 704 of 2023 is allowed, thereby granting bail to the petitioner on condition the charge sheet has not yet been filed, Mr. 180 days have not. On condition that the petitioner furnishes bond of rupees 10,000 usual gulo thakbe, to the satisfaction of which arresting special court NDPS Act at Coach Bihar. Full stop. To show it is like amount to next para. The petitioner shall, during the process of investigation, meet the investigating officer once a week and shall not leave the territorial jurisdiction of the trial court at any point of time. Full stop. Any point of time until further orders. Full stop. As and when the trial commences, the petitioner shall attend each and every date of trial and continue to remain within the territorial jurisdiction of the trial court. Full stop. That apart, the petitioner shall not make any directly or indirectly an inducement to course.
Liberty, my lord. One indulgence, my lord. One is, my lord, if you lordship may please to add one line.
Yes.
If the above conditions is violated by the petitioner, bail may be cancelled after hearing the petition.
After hearing the petition. Very well. I will put in a default clause.
And my lord, may be kind enough to record my presence as deputy solicitor general.
Solicitor General.
Instead of senior counsel.
Senior counsel na bole ota deputy senior counsel ta control find kore deputy solicitor general kore.
Grateful, my lord.
আরেকটা লাইন অ্যাড করে দাও যে in default of any of the conditions as stipulated above, the petitioner the bail will stand cancelled, upon giving an opportunity to the petition. Trial court once a week. Meet the investigating officer once a week. Yes, going to Kolkata. Yes. 63 is nothing. Call the next.
Lord, I appear on behalf of the petition.
My lord, in this case, if I am permitted, my lord, because it is there. But we have an instruction that one bail application is pending before the trial court, which is filed on 18th of this month.
The same petitioner?
Yes, my lord. On the same ground that he is ill, and the learned trial court has called for a medical status report to be placed before that court on 3rd of October. In spite of that, my lord, they have come before your lordship.
No. You cannot take a chance. We'll adjourn it till after 3rd October. Learned counsel for the petitioner, at the outset, learned deputy solicitor general submits that the petitioner has also filed a similar application for bail before the trial court on the same ground of illness, in which a medical report has been called for by the trial court and the matter has been fixed on October 3, 2023. Full stop. Next para. In view of such submission, we are of the opinion that the present bail application ought to be deferred till after the hearing of the said bail application by the trial court. Full stop. Accordingly, let the matter stand adjourned till October 4, 2023, when it will be listed before the appropriate division bench in the next set.
Lordship, one minute. There was a rejection even on 3rd of April. The
trial should be completed within 1 year. If not, he has a right to come for it.
On that, I can.
Touch that. Will not touch. Because since we have said that it is appearing before the trial court, let the trial.
With your lordship leave.
Thank you.
I once again apologize, my lord.
No, Mr. Abdul. Yes.
My lord, I'm 22, I'm for the petitioner, my lord. My lord, petitioner custody about 338 days, my lord. Charge not framed, charges have been submitted, my lord. And my lord, I have one gown. Kindly see the FIR, my lord.
Yes.
My lord, page 11, my application, my lord. Where, my lord, police described each personal lawyer. Search and nothing suspicious could be found out on anybody of my lord.
Which paragraph?
My lord, fourth line, my lord. First.
Neil Caesar list.
My hence all the police, my lord. In
Yes,
FIR.
Neil Caesar list.
Second.
No, then afterwards it was
Yes,
found.
my lord, Inspector of Gadget Officer has started the process of searching storeroom and said storeroom is present, no both accused. But my lord, no room belongs from my property, my lord. This is a.
What were you doing there?
My lord.
What were you doing there?
My lord, police police.
You are found there.
Found they search, my lord.
What were you doing there? That is my simple question.
My lord, nothing was made. There was not in my position.
May not be found from your position. You are in the same place. You are there. It was found from the storeroom. That is why the relevant question is, what were you doing there? You have to answer that at least. You have to explain your presence there.
There is no storeroom in my house, my lord.
We are not interested in your house, believe us. We are not interested in your house at all. It has not been said it's your house. You are present there.
I'm present. My lord, they have described that his house belongs to Sanjay Chhetri, my lord.
Where is that? The house is actually yours. You say there is no storeroom.
No.
But the house is yours.
House is my lord, but nothing was seized from my position, my lord. Police.
One of the rooms was described as a storeroom, maybe not, may not be a storeroom, maybe a kitchen, maybe bathroom, whatever. It is mentioned as a storeroom. It was found from a room of your house.
I appreciate, my lord, but nothing was seized from my lord. When they were seized.
Nothing was seized from my lord. No, definitely nothing was seized from me. From your possession? No, no.
My lord, not in my house.
Yes, you may, absolutely may.
My lord, kindly peruse annexure 18, my lord, of the petition.
Page 18.
Yes, sir.
Yes.
This is the last rejection on this month. First
No,
of this
page number must be different.
there is no change of circumstance.
Oh,
Circumstance changes, my lord.
should have started with this.
No, my lord. And on last
Two occasions it was
12th of November, 12th of September, my lord. Last day from office of coupling.
First September it was rejected. Today we are on 21st. 20 days only, no.
My lord, on that day, my lord, on 12th of September, my lord, date from supply copy and framing of charge value. But charge was not framed and copy not have been supplied.
That was not a ground for rejection.
And 338 days, my lord, custody.
Considered everything and it was rejected on first of this month.
Learned counsel for the petitioner contends that the petitioner is already in custody for 330 days and charge sheet has been filed, although no charges have been framed, full stop. That apart, the petitioner's house does not have a storeroom, although it was mentioned in the complaint that the contraband articles were recovered from the storeroom of the petitioner's house. For sub next para, learned counsel for the state opposes the prayer for bail and points out that on September 1, 2023 itself, that is 20 days back, a similar application for bail of the petitioner was rejected by a coordinate bench upon considering all aspects of the matter. Full stop. Although learned counsel for the petitioner submits that the circumstances have changed inasmuch as charges have not yet been framed even after the said order, we are not convinced that there has been any change of circumstances justifying grant of bail in the teeth of the rejection of a similar prayer on September 1, 2023, that is only about 20 days back. Full stop. Accordingly, CRM NDPS 740 of 2023 is dismissed.
Grateful, ma'am.
For the state lordship.
What happened after 1st March, Mr. Shahabuddin?
First March, my lord, till today, there is no progress in trial, my lord.
Hmm.
Next date fixed for supply of copy, my lord. Till today, charge not done, supply of copy on 25th September. It was fixed on supply of copy, my lord.
No.
I am about custody of more than 3 years.
Yes, anything else, Mr. Shahabuddin?
Long custody.
Hmm.
There is 14 charge sheeted witness. There is remote possibility of conclusion of early trial, my lord. My lord, there is some judgment, my lord, long custody petitioner may be enlarged on, but
Right.
this is my specific subject.
Yes.
Lordship. Actually, Lordship, one part is missing here. That this case went up to the 3 judges bench with Subhash Chattopadhyay. Latter, his bail application was considered by the single bench on 1st March, the division bench here on 1st March, and a direction was passed. And pursuant to the direction, Lordship, subsequently, what is the process? If one accused is absconding, another in custody, the splitting has to be done. For splitting, some execution reports are necessary. WA and WPA execution reports are necessary for splitting. Now, that procedure has already been initiated. Trial is progressing. In addition to that, the quantity of gaja recovered from him is huge. Is 283 kilograms of gaja. Much above the commercial quantity, Lordship. Moreover, Lordship, he is a resident of Bihar. A time frame may be given together with the earlier direction.
He has given an address of Murshidabad here.
That is, I don't understand, but my record, my entire city, my memo of arrest, everything showing the address of Bihar.
The trial is, at a very early stage. One never knows when it will be concluded. 14 charge sheet witnesses.
Give us at least 6 months time. At least 6 months. He's from Bihar. We won't be able to bring him back.
He's already in custody for 3 years.
Give us 6 months time, Lordship. At least to initiate the trial. Give us 6 months time, Lordship.
Yes. What about you not leaving territorial jurisdiction?
Direction, I will leave the
Lordship, it is very difficult. If he enters into his own state, Bihar, from Bihar, our police will not be able to find him out.
May I submit, my lord?
Huge quantity, Lordship. Otherwise, I would not have, had it been 24 kg, 25 kg, I would not have said anything, Lordship. It's 280 kilograms of gaja.
If your lordship directed,
সেই জন্য বলছি proclaimed offender deal করে ইয়ে করতে।
if your lordship directed to reside in the local limits of the territorial.
No, but it is difficult to enforce, Mr. Shahabuddin. You're from a different state. He is right on that.
I reside the local limits of the court, my lord. If your lordship pre-condition that where I reside, I intimated to the officer in charge of the Kotwali police station, Jalpaiguri. And this is the trial court order. I have this certified code. Kindly see what is the progress in the trial, my lord. Already 3 years elapsed, my lord. In 2 years, petitioner granted bail, my lord. Kindly see the order passed by the coordinate bench, my lord.
Yes, হয়ে গেছে দিয়ে দিচ্ছি দিয়ে stringent condition দিয়ে দিচ্ছি কি করতে 3 বছর ধরে ঢুকে আছে ওতে
Lordship, give us 6 months time at least to initiate the trial. Lordship, once he leaves West Bengal, Lordship,
no, my lord.
Lordship, 280 kilograms, huge quantity, Lordship. I humbly beseech.
There are 14 charge sheeted witnesses.
Lordship, give us 6 months time to initiate the trial. Thereafter, kindly give him a liberty to renew. At this stage, Lordship, if he is released on bail, Lordship, he will never come back.
No.
He will not face the trial, Lordship.
Learned counsel for the petitioner submits that the petitioner is already in custody for more than 3 years. First, there are 14 charge sheeted witnesses and the progress of trial is very poor. Full stop. Learned counsel for the state vehemently opposes the prayer for bail and submits that the petitioner is a resident of a different state, that is Bihar, and if the petitioner, taking advantage of the bail, escapes to his native state, it would be extremely difficult to arrest the petitioner again. Full stop. Moreover, it is argued that the prosecution is taking its is making best endeavors to conclude the hearing at the earliest. Full stop. It is further submitted that if 6 months time is granted, it is expected that the trial will be concluded by that time. Full stop. Next para. Keeping in view the repeated observations of the Supreme Court in various judgments that long period of incarceration itself justified alleviation of the restriction under Section 37 of the NDPS Act and entitles a person to bail, as well as the fact that there are 14 charge-sheeted witnesses, which indicates that the trial may not be completed as yet, particularly since there are several absconding accused persons, we are of the opinion that bail ought to be granted to the petitioner. Full stop. Next para. Accordingly, CRM NDPS such as 742 of 2023 is allowed, granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 20,000 with 2 sureties each, one of whom must be local, to the satisfaction of the Special Court NDPS Act at Jalpaiguri. Full stop. The petition further, the petitioner shall not leave the territorial jurisdiction of usual যেটা থাকে সেটা থাকবে, তার সঙ্গে একটা অ্যাড করতে হবে. Moreover, the petitioner shall
Lordship, may I add one?
Yes.
Lordship, for ensuring his appearance, Lordship, let there be a local surety having landed property within the territory of Jalpaiguri, within Jalpaiguri town.
Yes.
Landed property within Jalpaiguri town.
প্রথম প্যারাগ্রাফ যেখানে বললাম to the satisfaction of the court, সেখানেই ফুল স্টপে পড় হবে. It is made clear that the local surety furnished by the petitioner must have landed property within the territorial jurisdiction of
Jalpaiguri town, Lordship.
Jalpaiguri town.
Town or Jalpaiguri?
Within Jalpaiguri, within Jalpaiguri. বাকিটা যা আছে থাক। শেষ হচ্ছে ওখানে। Yes. We can direct the petitioner to meet you also once a week.
No.
In leisure hours, after court hours.
Huge lordship.
At night, he will be meeting you every week.
There is a Pastova matter, item number 10.
If the petitioner is there, you are the petitioner. 10 নিয়ে পাসওয়ার্ড ওটাগুলো নিন। Yes.
I have only one point in this matter. Can you see the arrest memo of Aditya Nansiri? Arrest memo signed by Pappu Ali, who is the case under.
Who is one of the co-accused?
No, my lord. Pappu Ali is the resident of police station of Jalpaiguri, Jalpaiguri, and the case under Pradhan Nagar police station. My specific, it was near in front of a hotel, my lord. This person not a respectable member of that locality. This is my specific.
You are in custody for?
Custody of near 151 days.
Lordship, whether Pappu Ali lives in that area or not, that is a consideration of trial.
In the written complaint, yes, specific
compliance.
In the complaint, he says in the complaint it is indicated.
In the complaint, page 9, my lord.
Independent witness, a seizure witness, independent, maybe he is living temporarily, he is working or living in that area. His presence was there, Lordship. Prima facie presumption violation of.
No, presence is not sufficient. He has to reside in the locality. That is also one of the conditions.
Trial. He will explain during cross-examination.
Now let us see your complaint. Which paragraph?
Yes, my lord. Middle paragraph. After reaching in front of hotel, parking lot, I requested 2 persons as independent witness by namely Dhananjay Rajbal, such as Pappu Ali, son of Sapor Ali, Jalpaiguri, PS station, Siliguri, Darjeeling.
Which PS station case is this?
Pradhan Nagar, my lord.
Middle. It is within just, it takes only 1 hour.
No, charge sheet has not been filed.
The charge sheet has been submitted. That's what. And charge sheet has been submitted. Lordship, case is very good.
It's too early for granting. The petitioner contends that Pappu Ali, the alleged independent witness in the memo of arrest is not a resident of the locality. As such, the memo of arrest is vitiated, hence it is submitted. The presumption under section 37 of the NDPS Act does not arise. Next para. Learned counsel for the state opposes the prayer for bail and contends that whether the said independent witness is a resident of the locality is a matter of trial and cannot be decided at this premature stage. Further, it is argued that the presumption under section 37 of the NDPS Act is not mitigated in any manner. Next para. Upon considering the submissions of the parties, we are inclined to lean in favor of the submission of the state insofar as the presumption, the restriction under section 37 of the NDPS Act is operative. The argument of the petitioner is, at best, a matter of trial. Accordingly, CRM NDPS 726 of 2023 is dismissed.
This is the status report, kindly see where the charge was there.
How many witnesses in total?
Total 14, this renewal of prayer, earlier it was rejected on 2nd of August 2022, and charge was framed 21st of July 2022. But after rejection, there is no progress in the trial. And kindly see the status report, 6 days has been fixed, and but no evidence has been turned up. No. And I'm in custody about 2 years, 725 days.
Order sheet, where is the order sheet? It is not good order sheet. Nothing is clear. Bring the order sheet. Bring the order sheet.
You are in custody for 2 years.
Yes, sir. 725 days.
Resident of Bihar again, Lordship.
We cannot have a bias against Bihar.
For NDPS training, you were informed that the police officer, whenever Bengal police enters into the Bihar.
Justice Kumar will, my learned brother will decide this issue.
Lordship, the entire effort of the investigating agency will end in smoke if we cannot bring him back for
This was brown sugar or gaja?
Gaja, 43 kilos.
Then it has to end in smoke. Either way. No, sufficiently incarcerated. The petitioner is already in incarceration for more than 700 days. It is submitted by learned counsel for the petitioner, by placing reliance on the
on one point.
Let us complete the sentence first. Relying on the case status, that the trial is going on indefinitely. There are 14 witnesses in total. Hence, it is apprehended that the petitioner will have to suffer long incarceration till the trial is disposed of. Yes, what is your point? He said that. Next para. Learned counsel for the state opposes the prayer for bail and submits that the petitioner is a resident.
17/5/2022.
Lower court rejection.
Thereafter, High Court rejected the petition.
Learned counsel for the state opposes the prayer for bail and submits that the petitioner is a resident of a different state and may escape if enlarged on bail. Further, it is contended that in the event the petitioner is released on bail, the trial may be affected. Next para. Learned counsel further submits that the petitioner's previous prayer for bail was rejected as well. So we find from the records that the previous rejection of the petitioner's similar prayer was on August 2, 2022, which is more than 1 year previous, 1 year back. The petitioner, in our opinion, has sufficiently suffered incarceration and it is uncertain as to when the trial shall be concluded, full stop. Hence, in our opinion, the petitioner is entitled to the benefit of bail. Accordingly, CRM NDPS 745 of 2023 is allowed. Satisfaction to have a special court NDPS Jalpaiguri. 10,000 two COTs like amount is Baki Sabha.
I'm applying the petition.
Yes.
41B not compliant. Page 12, coordinate bench has granted bail to a court standing on the same footing.
Same footing?
Page 12.
Yes, what do you say?
Won't be compliant. 41B compliant, my lord.
41B not compliant was observed by a coordinate bench. Page 12.
Lady, one lady was
Yes,
there,
my lord.
Saraswati Vishwas.
Lady constable signed the.
On the condition that the lady, accused cannot be search seizure, that's what the mention your lordships. But the others, so for other concern of the accused, complied your lordships. Only 7 except this lady, your lordships. I was that time, in this case also I am for the prosecution, your lordship. I asked the IO, he said due to lack of knowledge. And regarding this others.
No, lady, the same logic applies. It was observed by the court on the previous occasion that IO was under a mistaken belief at the relevant point that a lady officer should sign the memo of arrest in case of a team raiding a lady. So that was the misconception. In his case, it is all the less applicable because he's a male. That misconception could not have arisen in your mind. So here also the signing person was a member of the raiding team.
No, individual, local resident, everything is.
My lord, kindly came to the FIR, my lord, page 10 of their annexure. Page 10, my lord. Second para, my lord. Thereafter, we reached at Amtola. And two independent witness, namely Monukor, and Monukor signed the 41. As because on that time no lady was there, that's why it's happened.
He was arrested in a different time.
No, same time.
Same seizure list, same memo of arrest.
Same seizure, but as because it was lady.
No, for the lady, at the time of arrest, the memo of arrest of the lady was signed by a different person than his memo of arrest.
Yes, my lord. The lady, one lady constable signed the memo of arrest of.
But in his memo of arrest, it was signed by.
Independent. And it reflects from the page 10 of their annexure.
Only there is only female.
The case was initiated on 4th June, my lord. 4th June 2023.
What was your other ground? Section 41B coordinate bench. This is the only ground. 41B and coordinate bench merges. So that was the ground. How long are you in custody?
1 kg.
Learned counsel, no, we are not granting. Learned counsel for the petitioner contends that the petitioner is entitled to bail, in view of violation of section 41 capital B of the Criminal Procedure Code, as well as in view of the fact that a co-accused person on similar footing was released on bail by a coordinate bench with a order dated August 17, 2023. Full stop. Next, learned counsel for the state opposes the prayer for bail and submits that the petitioner is not on an equal footing as the co-accused who was enlarged on bail by the coordinate bench. Full stop. In the said case, the co-accused person was a lady, and there was a misconception on the part of the IO that a lady police officer should sign the memorandum of arrest, due to which a lady member of the raiding party had signed the memo of arrest, which vitiated the arrest in the perception of the coordinate bench. within the contemplation of section 41 capital B of the CRPC. Full stop. However, comma, in the case of the present petitioner, comma, an independent witness duly signed the memo of arrest as such, comma, the provisions of section 41 capital B of the CRPC were duly complied with. Full stop. We find that the petitioner is only in custody for about 110 days, and the yardsticks which were the basis of grant of bail to the co-accused lady do not apply to the present petitioner in view of the discussions as made above. Full stop. Hence, comma, the ground of parity is not applicable to the petitioner, and as such, the presumption of section 37 of the NDPS Act operates in the present case. Hence, CRM NDPS 747 of 2023 is dismissed. Sorry, Mr. Banerjee, but yes, Mr.
27th February 2023. And your lordship in this case, charge sheet has been filed 22nd August 2023. Now the very astonishing thing is that your lordship kindly take the page number 11. The property description. Kindly. One truck bearing registration number NL01C8536. She got it. Then one truck was seized as per the seizure list. Even now, can you see your lordship the seizure list? In the seizure list, page number 15. The number of the vehicle which was containing contraband, can you see? The page number 15, column number 5, small Roman 1. NL01G8536. Now can you see the page number 13, line number 4. The last one. Page number 13, line number 4, the last one. The number of the vehicle. Which he explained. He explained due to the paid mistake, the de facto complaint stated in the FIR, the offending vehicle was 8536, but subsequently it was revealed that the original vehicle number is 8534. Now can you see the FIR? In the FIR, that has been mentioned 8536. In the seizure list, in the property description, that has been mentioned in the 8536. In the seizure list, in the column number 5, the vehicle number has been mentioned as 8536. But in the after lapse of 6 months, when the charge sheet was filed, they realized the de facto complaint wrongly put the number of the vehicle as 8536 instead of 8534.
You are the driver of the vehicle.
That is valid.
There is a pen drive which contains a video clipping of recovery of gaja, Mr. Bhomik, and you were found in the vehicle as per the video clipping also. The number of the vehicle could be relevant for the owner of the vehicle, but not for you. The vehicle was seized, there was gaja in that. Misrepresentation of the number in a particular document cannot vitiate arrest.
I was arrested on 27th March, February.
So,
lordship, can you take the page number 13? That is the charge sheet. The inventory was done on 13th March. The seizure was effective on 27th. After a lapse of 15 days, without an explanation in a test sheet, the inventory was done. And during that 15 days, the entire articles which were allegedly contraband in the police custody. And the certificate of authentication was done on
15, 30, after lapse of 15 days. And after lapse of 18 days, that has been sent to the FSL for report.
18 days after the inventory. 18 days after the arrest. That means after 3 days.
Now, in this regard, your lordship, on a broader presentation on observation, passed by the honorable coordinator. There is a 52A non-compliant. 52A subsection 2. Even the judgment of the Honorable Supreme Court of Hon'ble was also relied upon. There was also no explanation of that inordinate delay.
There was an additional factor. The application for certification was there made on 15th of February. Here the certification was only 3 days after.
But within 27 to 30, 15 days.
You were captured you were found in the vehicle. Truck was.
That is not a case. I was the driver of 8536, and the vehicle from where the alleged contraband were recovered, that is 8534. Because that vehicle driver was fled away, I have been apprehended because there was a Naka checking was there. Several vehicles were apprehended.
No, Mr. Learned counsel for the petitioner places reliance on primarily on 2 factors to argue that the presumption under section 37 of the NDPS Act is not applicable. First, it is pointed out that in the charge sheet, as well as the seizure list, the vehicle from which the contraband article was allegedly seized has been mentioned as registration number NL01 capital G stroke 8536. সাবধানে লিখতে হবে, এখানে যদি আবার ভুলে যায় আবার এটা ground হবে 8536. However, in the complaint it was mentioned that the complainant, who corroborated with FIR also stated that due to within double inverted pen mistake, double inverted close, he mentioned the registration number of vehicle NL01G stroke 8536 in lieu of NL01G 8534. It is argued that hence, there is ample doubt on the vehicle which was actually found to be carrying the contraband articles. That apart, learned counsel argues that the samples were allegedly seized on February 27, 2023, but was sent for inventory on March 13, 2023, and was thereafter sent for chemical examination after 3 days. The huge delay in the interregnum, it is argued, tantamounts to a violation of section 52 of the NDPS Act, 52 capital A of the NDPS Act. Learned counsel places reliance on a coordinate bench judgment dated September 6, 2023, where the division bench had observed, by placing reliance on Union of India versus Mohanlal and another, reported at 2016 3 SCC 379, that in similar circumstances, prima facie the provisions of section 52 capital A of the NDPS Act have been violated. Learned counsel for the state opposes the prayer for bail and contends that the alleged discrepancy are minor and technical. It is further submitted that the rigors of section 37 of the NDPS Act are attracted in the present case. We find from the documents on record that in the charge sheet, it is clearly indicated that the contraband articles were recovered from a truck. Full stop. It is further mentioned that one pen drive in which entire search and seizure video clip was recorded was also a part of the charge sheet. Full stop. Next para. In such context, comma, since the petitioner was the driver of the offending vehicle, comma, we are of the opinion that the video clip, comma, in conjunction with the description of the articles and the truck are sufficient to prima facie indict the petitioner, comma, irrespective of the technical, irrespective of the minor technical flaw, as pointed out in the complaint regarding the number of the vehicle. Full stop. It cannot be gainsaid that the petitioner, comma, along with the contraband articles, comma, was prima facie apprehended in a truck which has been described in the charge sheet as well as the complaint. Full stop. The seizure list also corroborates with the charge sheet as well as the complaint. Full stop. Hence, comma, we do not find any palpable violation of the of law in the process of seizure and arrest. Full stop. Insofar as the coordinate bench judgment is concerned, comma, we find that in the said case, comma, the commercial quantity was seized on January 2, 2022, and the same was sent to FSL for examination on January 5, 2022. Full stop. In the said case, comma, remarkably, comma, an application for certification was made on February 15, 2022, comma, that is after about 21 days from the sample being sent for examination. Full stop. However, comma, in the present case, comma, there is no such contravention of section 52 capital A of the NDPS Act insofar as the certification preceded the sample being sent for examination. Full stop. Hence, comma, we are not inclined to accept the contention of the petitioner. Full stop. The regards of section 37 of the NDPS Act are fully applicable in the present case. Accordingly, CRM NDPS 749 of 2023 is dismissed. After line according, it is expected that the trial shall be concluded expeditiously. Expeditiously. Thank you.
My lord, I am praying for time. A CD is gone.
Nothing. Sorry. Not today, tha. Then not today, not today. No, not in every matter, no. Not press. Learned counsel for the petitioner submits that the petitioner does not want to press the present application for bail. Accordingly, CRM DB number 214 of 2023 is dismissed as withdrawn.
Lordship, I am for the petition. Lordship, the petitioner was arrested on 24/4/2023, basing upon a complaint lodged by the maternal uncle of the deceased, that is the wife of the petitioner. The FIR was lodged under section 498A by 302 IPC. On the very next day, the petitioner was arrested. Subsequently, after the charge sheet,
Maternal uncle of whom?
the wife. The wife committed suicide by hanging, but the case was of 302 murder. After investigation, police found that no, it was not a murder case, it was a suicide case and submitted charge sheet under section 498A along with 304B IPC. Lordship knows that if unnatural death occurs within 7 years of marriage, is a statutory presumption of 304B. So charge sheet has been submitted. Now total 18 witnesses are there. No witness has started yet. I am in custody since the second day, that is 24/4/2023, Lordship. Charge sheet has been submitted. The sole accused. Now, Lordship, I humbly pray that custodial interrogation is no more required. I will face the trial, Lordship.
Yes, what do you say? Yes, that's as per the presumption of law. So we are granting bail. Learned counsel for the petitioner submits that initially it was alleged that the petitioner is guilty of murder of his wife under section 302 of the Indian Penal Code. First up, accordingly, the sections initially alleged against the petitioner were section 302 as well as 498 capital A of the Indian Penal Code. First up, however, subsequently it was found that the victim had committed suicide, for which under the statutory presumption of law, since the period of 7 years had not elapsed after marriage, sections 498 capital A and 304 capital B of the Indian Penal Code were clubbed against the petitioner. Next para, we find that the nature of the allegations against the petitioner, at present, are of a lighter nature than section 302 of the IPC, insofar as the offense of section 304 capital B of the IPC has been added under the statutory presumption of law. Hence, we are of the opinion that custodial interrogation is no longer necessary. Accordingly, CRMDB 567 of 2023 is allowed, granting bail to the petitioner on condition that the petitioner furnishes bond of rupees 10,000 with 2 sureties like amount usual to the satisfaction of learned. Yes.
The case is now before additional session judge Dinhata.
To the satisfaction of the learned additional sessions judge Dinhata. Rest of the conditions shall not leave the territorial jurisdiction, shall attend Nigeria.
Deep level.
Yes.
This case relates to 302 and 34 and other sections.
Yes.
Now there are 3 persons. Actual fact is that your lordship, being a student of law, I think if we assume the story of the prosecution, then it may come under the purview of 304 part 2, rather than 302. Because if your lordship can take some glimpse, the 304 exceptions are there. Who is the distinction made between the 304 and 302? That the premeditation should be there. But so far this present case is concerned, this is the unfortunate petitioner had a love affair with a girl, and the deceased, he was disturbing her. Over that issue, a hot altercation took place prior to
disturbing you.
Deceased my girlfriend. Yes. And over that issue, prior to 10 to 12 days of the alleged incident, I threatened him that if you disturb my girlfriend, you have to face the dire consequence. Subsequently, on the 18th December 2022, so for the allegation is concerned, I, along with my 2 brothers, called him but in a particular place where he also came with his 2 brothers. Scuffling took place. During the scuffling, both the parties got injuries, and subsequently the deceased succumbed to his injury. And there are 3 persons.
You shall also implicate the girlfriend. You shall also implicate the girlfriend.
Lordship. As your lordship. Now the
yes.
So for the case is concerned, your lordship.
302 is serious. I mean,
302 is very serious.
For that reason, your lordship, I am drawing your lordship's kind attention. The section 304 exception to attract section 302.
You are the prime accused. There is allegation of stabbing against you as per the order of the trial court also.
Lordship. Now,
if you stab a person deliberately, it's doubtful whether it's 304 or 302.
Was the allegation in the 164? 164 said a scuffling took place. In the meantime, I went to my house and took a knife from my kitchen and stabbed him. So there is no premeditation. Number 1. Number
You
two,
took, went to your home, took a knife from your kitchen,
There is
came.
consequence.
There's no premeditation. What is premeditation, Mr.
Now,
Bhavik?
Lordship, there are, I mean.
You have to meditate on that prior to it. What is premeditation? You went back home, took the knife from the kitchen, came and stabbed him. Is this not premeditation? I mean, how are you arguing this even?
No, in this case, charge sheet has been filed.
Yes.
Then I am 2 persons are on bail.
You are the principal accused.
That has been a allegation of the de facto complaint in this scheme. Now, 273 days I am in custody. I am a local resident. Imposing any stringent condition that I will not entertain jurisdiction of the POCSO police station and inform them.
Why is further custody necessary? Otherwise, it's yes, he's the principal accused, apparently so. That was the ground on which bail was refused also in April by the trial court. But why should he remain in custody? I mean, bail is the rule and all these things are.
Not to tamper.
Learned counsel for the petitioner submits that he is already in custody for 200 and Mr. Bhavik, 200 and how many days?
275 days.
For 275 days. Full stop. Next para, it is further argued that in the absence of premeditation, comma, the appropriate provision which was required to be clubbed is section 304 and not section 302 of the Indian Penal Code. Full stop. Next para. Learned counsel for the state opposes the prayer for bail and submits that the petitioner was the principal accused and his bail was refused on April 25, 2023 by the trial court. Full stop. Although we cannot accept the submission of the petitioner at this stage, comma, that the offense pertains to section 304 as opposed to section 302 of the Indian Penal Code, comma, since the same is a subject matter of trial, as well as we keep in view the fact that the petitioner was the prime accused in stabbing the victim, comma, we find that custodial interrogation or trial is no longer necessary at the present juncture, comma, since the trial is underway and the petitioner is already in custody for more than 200 for about 275 days. Full stop. Hence, comma, CRM DB 568 of 2023 is allowed. A usual condition to the satisfaction of which court? Chief Judicial Magistrate, Jalpaiguri. Conditions গুলো একই থাকবে।
in the today's item number 1, my lord, the designation has been wrongly given, my lord.
What designation?
The additional public prosecutor is little.
Oh.
So in paragraph 5, 6, 7, 12, 15.
We should make it learned council.
Additional.
Oh. ঠিক আছে দাও এটা কাল টু মেনশন we'll keep it as 2 mention to 1 and rectify the we have passed an order in open court so we cannot rectify that. It will appear as 2 mention tomorrow. Just please point out when it's yes.
I have a small question. So, regarding the item number 106, CRM NDPS April 7 of 2020. The Lordship, the petitioner's mother is often on serious old age disease. So, your Lordship, kindly see this matter tomorrow in the morning.
Why didn't you mention in the morning?
Your Lordship, I failed to mention in the morning, so I
No. Sorry, no. Column list.
Lord, I'm for the petition and such. Lord, this is an application for bail, my lord, arising out from Lord offences under the POCSO Act, Section 4 of the POCSO Act. My lord, the petitioner is my lord 26 years old, and the victim was 16 years old at the relevant time. And my lord, charge sheet has been submitted. My lord, even the victim girl's evidence is also, my lord, has been completed. My lord, I am in custody, my lord, 5 months, 2 days. As of now, my lord, my custodial detention is no more required further, my lord. My lord, in any condition, my lordship, my lord.
Yes, for this.
My lord, 160. Page 25, my lord. The 164 statement of the victim. Page 25, 25.
Yes, but otherwise the victim's evidence has been taken. How can he tamper? I mean, we'll put in conditions.
Not under the jurisdiction where.
You are deciding in a separate police station.
Yes, my lord. I mean,
Same
Undibari police station. Same
locality, not to enter the jurisdictional residential jurisdiction of victim.
Learned counsel for the petitioner contends that the petitioner is already in custody for more than 5 months. Full stop. Moreover, the victim's evidence has already been taken and the trial is proceeding. Full stop. It is submitted that there was a relationship, there was an affair between the petitioner and the victim, who were respectively 26 and 16 years of age at the relevant point of time. Which of next para, learned counsel for the state opposes the prayer for bail and points out that the allegations are under the POCSO Act. Which of that apart, it is submitted that the statement under section 164 of the Criminal Procedural Code is incriminating against the petitioner. Which of next para, it is further submitted that the medical examination also clinches the issue against the petitioner. Full stop. Even without going into the strength of the allegations against the petitioner, which will be decided in the trial, we are of the opinion that since the victim's evidence is over and the petitioner apostrophe's custodial interrogation is no longer necessary, the petitioner ought to be granted the benefit of bail under certain stringent conditions. Full stop. Accordingly, CRM DB 569 of 2023 is allowed, granting bail to the petitioner on condition that the petitioner furnishes bond of usual to the satisfaction of the special court POCSO at Kuch Bihar. Full stop. বাকিগুলো যা থাকবে সব shall not leave the territorial jurisdiction. Moreover, তারপরে একটা অ্যাড হবে. Moreover, the petitioner shall not approach the vicinity of the residence of the victim girl and or attempt in any manner to approach the victim girl or contact her throughout the period of trial.
Grateful, man.
Good.
I'm for the statement.
I'm for the petitioner, Lordship. Lordship,
302 lordship charge sheet has been submitted against 5 accused persons. 3 accused person has been released on bail by the learned coordinate bench. Lordship, I have annexed all the order sheet, and one of the co-accused person has been released by your lordship on by.
So, are you on a similar footing?
Yes, similar footing. The petitioner is also standing on the similar footing.
Similar footing. Learned counsel for the petitioner submits that charge sheet has already been submitted, and then other co-accused person and three other co-accused persons on similar footing as the petitioner have already been enlarged on bail. Full stop. On the principle of parity, we are of the opinion that the petitioner should also be given the benefit of bail. Accordingly, CRMDB 572 of 2023.
My lord, there is eyewitnesses there, but names are there, my lord. But same.
Same conditions to the satisfaction of which court?
SCGM Alipurduar.
SCGM at Alipurduar. Satisfaction, rest of the conditions remain same.
CGM Alipurduar.
Learned CGM Alipurduar.
Great.
Yes, ma'am.
This case relates to POCSO. I am 27 years old and the victim was 17 years, 4 months. There was a lava before pay from bail to lodge.
164 is clinching against him.
Yes, ma'am. Lordship, now this is the document. They have got married.
They have got married.
Subsequently,
Madam, kindly go to the 164 statement, madam.
164, yes.
164 may be against me at this stage.
Madam, kindly go through the 164 statement.
Maybe against me, but
page 21 to 22, my lord. The reverse side of 21.
No, Lordship, maybe under the pressure of their guardian, she may be turned off.
Ravished several times upon the VG. Reverse side of the page 21, madam.
Seen that, yes.
Now both are. Now they are both of.
No, Mr. Bhomiki, just because you had a relation, she said no, that means no. She said no, that means no. Just because you had a relation, you could not have her. Anyway, but what are the other circumstances? You were in custody for how long?
I am in custody since 110 days, your lordship. Charge sheet filed. For the purpose of custody interrogation, my detention not necessary. I may be asked to not to enter the jurisdiction of the entire police station.
You are of a different police station.
No, man. I am in
same police
station. I maybe reside elsewhere.
Reside in the same premises.
If he is agreed to reside elsewhere, then
What's your name?
My lord, it may hamper with.
How? It is a presumption, your lordship.
No, my
this
lord,
is nothing but a presumption.
Clear statement.
I am undertaking, lordship, I am undertaking that I will stay elsewhere without the jurisdiction of the Kotwali police station.
How he can marry a minor girl, my lord?
We'll put in a default clause also. Learned counsel for the petitioner contends that the petitioner was about 27 years of age and the victim girl about 17 years, 4 months of age at the relevant point of time. Full stop. It is indicated that there was an amorous relationship between the petitioner and the victim. Full stop. Subsequently, under family pressure, it is argued that the offense was alleged. Full stop. It is even argued that there was a marriage between the petitioner and the victim. Full stop. Next para. That apart, learned counsel for the petitioner submits that the petitioner, if granted bail, is even agreeable not to enter the police station of the where the victim girl resides, although the petitioner is a resident of the same police station area. Full stop. Next para. Learned counsel for the state vehemently opposes the prayer for bail and submits that the allegations in the statement under section 164 of the CRPC clearly incriminate the petitioner. Full stop. In view of the gravity of the allegations, it is submitted that the prayer for bail should be refused. Full stop. We find from the submissions of the parties and the material annexed that the proximity of the ages between the the proximity of the age of the victim to majority at the relevant point of time furnishes a mitigating factor to the extent that there might have been an amorous relationship between the parties, full stop. However, comma, it will be decided in the trial whether there was actually any such relation, full stop. Irrespective of such relation, comma, it is found that the allegations against the petitioner are serious. Full stop. Next para. However, comma, since the since the trial is already on way, comma, we are inclined not to further incarcerate the petitioner, subject, comma, however, comma, to stringent conditions. So accordingly, CRMDB 573 of 2020 is allowed. Sub একই থাকবে to the satisfaction of special court
POCSO Act Jalpaiguri.
POCSO Jalpaiguri. বাকিগুলো একই থাকবে, শুধু লাস্টে অ্যাড হবে। Further, comma, the petitioner shall not enter the territorial jurisdiction of the police station where the petitioner, where the victim resides throughout the period of trial, and shall not, comma, in any manner whatsoever, comma, attempt to contact the petitioner or her near relatives and or any of the witnesses. Full stop. In default of contravention of any such conditions, comma, the bail granted to the petitioner shall be cancelled upon giving an opportunity of hearing to the petition.
Grateful.
Yes, Lordship, I know the petition of Lordship. Lordship, under section 363, 365 IPC and adding section 6 of POCSO Act, Lordship, there, Lordship, the relationship between the parties, Lordship, and the petitioner is 27 and victim is 17 years old, Lordship. Lordship, the petitioner languishing in custody 3 years, 2 months, 18 days till date now.
Due to the period of custody, we will grant. Yes.
Lordship,
Only take into consider the period of custody. We shall not go into the rest of it. Learned counsel for the petitioner submits that the petitioner was 27 years old and the victim girl about 17 years old at the relevant point of time. Full stop. Next para. Hence, comma, there was a relationship between the two. Full stop. Moreover, the petitioner is languishing in jail for more than 3 years. Full stop. Next para. Learned counsel for the state opposes the prayer for bail and submits that as per the statements made under section 164 of the Criminal Procedure Code and other surrounding circumstances, comma, the gravity of the offense of the petitioner is serious. Full stop. Be that as it may, comma, keeping in view the period of custody of the long period of custody of the petitioner, comma, we are inclined to grant bail to the petitioner. Accordingly, CRMDB 574 of 2023 is allowed, granting bail to the petitioner. Usual conditions to the satisfaction of the special court POCSO at Kuchbihar.
POCSO court, Mathabhanga.
আচ্ছা, POCSO special court POCSO Act মাথাভাঙা, comma, কুচবিহার। আর আরেকটা অ্যাড হবে কন্ডিশন, throughout the period of trial, যেগুলো ইউজুয়াল থাকে সেগুলো থাকে, throughout the period of trial, the petitioner shall not try, attempt in any manner to contact the victim and or go to the close proximity of the residence of the victim in any manner.
Good.
Yes.
Lordship, I am for the CBI. My lord allows me to produce the CD. We could not produce the CD.
Tomorrow?
Tomorrow it will not be possible.
Very well.
We will file a report with all antecedents and circumstances.
Very well. On the prayer of learned Deputy Solicitor General, comma, the matter is adjourned till the next circuit to enable the CBI to file a report as well as all connected relevant documents. Yes. Mr. Basu is there.
Yes,
Who allowed Mr. Basu to come to this? Yes, who allowed Mr. Basu to enter Jalpaiguri, not this court?
No, my lord. No, my lord. With the court's direction is there, how can I?
No, Mr. Basu does not know that the matter was mentioned yesterday, that your designation was not mentioned in the order. On that ground, it was mentioned for correction. That Mr. Basu does not know that. We furnish this to Mr. Basu so that he can ask for a treat from. Yes, for the bar. Yes, it's in public interest. On that ground, it was mentioned for correction. We did not correct. We said no, that is not a ground. No, we did not correct, but it was mentioned on that ground. We should give a treat to all. Yes. And Mr. Singhani was the responsible person. Yes. Yes, yes. Yes, what is the matter? Yes, Mr. Shah.
Lordship, the petitioner is the co-accused. Lordship, the principal accused has been released on bail by this by the coordinate bench of this honorable court. Lordship, the petitioner was served with a statutory notice under section 41A of the Code of Criminal Procedure on 9th of September 2022. On the next day, 20th of September 2022, I responded and some seizure was made.
420, Mr.
Yes, Lordship, this is my lord, only involvement of 3 crores.
Only involved 3 crores.
My lord, this is a Ponzi scam.
Charge sheet has.
But what about the principal accused being?
My lord, I'm coming to that. That is a very nice story given to a lord. Principal accused actually, I do not know why he is being made principal accused.
Then Mr. Mujumdar, let him complete, then we'll come back to you. Yes, yes.
Because the principal accused, why I'm saying was the chief managing director, whose name is Sunil Kumar Sarkar. He is the principal authority to take decision and all. Lordship, he was arrested by the CBI and subsequently he was released on bail. Lordship, kindly see the findings of the bail at page of my application at page.
What is the stage of trial, Mr. Shah?
Trial has not yet been started.
Charge sheet has been filed.
Charge sheet submitted against 8 accused persons, out of whom 4 are juristic person, 4 are individual person. Subsequently, supplementary charge sheet was submitted against 1 accused person.
Mr. Shah, then in view of the nature of the allegation, if you are released on bail, and you may influence evidence.
2023, sorry, 2013, FIR was. Subsequently, investigation was conducted for the last 10 years, and charge sheet has been submitted on 6th of January 2023 against 8 accused persons, citing all the materials. Not only that,
when were you arrested?
I was arrested on 13th of May 2023. And on the same day, the principal accused, that is Sunil Kumar Sarkar, who was also arrested. And he was also released on bail by the coordinate bench on July. Now the petitioner, is the co-accused person. And supplementary charge sheet has been submitted, Lordship. And again another accused person. So what is the utility for keeping me behind the bar for an indefinite period of time?
Lordship.
Yes.
My lord, these persons were given notification of the case pending. They absconded. They absconded until the Central Bureau of Investigation could pick them up this year. And my lord,
You were interested with this investigation when 2013?
no. 2021, we re-registered the case after the direction from the Honorable Supreme Court. And my lord, they are absconding. And I do not know, my lord, what is principal accused and what is co-accused.
Even if not a principal accused, Mr. Mujumdar, even if a co-accused was released on bail on 11th July, why shouldn't he be given this?
Another order of the coordinate bench was anticipated of the accused. My lord, they will abscond.
I was served notice and I complied with all seizure has been made from my lordship at page. Kindly see. At page 17, the seizure was made.
But Mr. Mujumdar, in this refusal of anticipated bail, undoubtedly, but here it was never argued that a co-accused had been released on bail. It was never argued. We don't find reflection of that. Have you got another copy of this?
If I am permitted to produce the application before your lordship, they take this plea.
But it was never application. We don't look into. Mr. Mujumdar, there was no consideration of that. We don't find that.
My lord, this is an indivisible. I do agree with your lordship. But this person was picked up after much long chase. He knew the case was pending. Notices were served upon. He did not receive them. They were running away from the court. What made them? What made them not to appear before the trial court and seek bail?
We are mostly bothered, Mr. Mujumdar, about this bail because the anticipated bail refusal did not take into consideration. This is the most.
If your lordship put this question to me, that what is the use of keeping him behind the bars? We need to find out where that 3 crores of rupees has gone.
No, not that, Mr. Mujumdar. It's a question of parity. If a similar person, a co-accused person on similar footing, it was observed by the coordinate bench on that occasion, we have produced the material, given due consideration, we are satisfied that in course of investigation, sufficient incrimination have been collected.
The person who's being referred as principal accused on bail.
We are not going on principal accused, co-accused.
these allegations were not against him. Rather, he spilled the beans that these are the persons who did the miscreations. The Joyga branch officer was the name of this accused. There was no such allegations against Sunil Sarkar, the person who was in bail. Rather, Sunil Sarkar says that I was induced by Apurva Karji, Shanot Rai, and Nikhil Doctor to do this business. They were the inducers, floaters, promoters.
Mr. Shah, no.
May I reply?
Yes, give a reply.
So what is that my friend submitted? So I am answering in a particular way. Also, that kindly see at page 16 of my application. The statutory notice I was served on 19th of September 2022. Pursuant to the direction of the Honorable Supreme Court, CBI takes up the matter for investigation. And subsequently, first time he was served with a notice on 19th of September 2022. Now, next day, that is on 20th of September 2022, I met with the CBI. Then the very next day, I met with the investigating officer, and all seizure has been made. So whatever documents was with me is all documentary based offense. I submitted. Then thereafter on 13th of May 2023, I was taken into custody. I even not taken into custody, but I was not remanded into police custody. They even not sought for police custody. I was simply remanded to judicial custody. Subsequently, the supplementary charge sheet has been submitted, where it has been categorically stated at page 41 of my application that Sunil Sarkar and Nikhilesh Datta were the key member, and during work.
What is the charge sheet?
In the supplementary charge sheet at page 41. I'm reading out from the relevant portion, where it has been categorically mentioned that Sunil Sarkar and Nikhilesh Datta were the key members, and during his working, Nikhilesh Datta regular guided Sunil Sarkar for any work. This is their categorical statement from the investigator.
What is your allegation in this charge sheet? Allegation against you? I'm sorry.
409.
No, where is your name mentioned in this charge sheet?
In the charge sheet.
Show us that.
I'm showing.
We want to see the allegation against you.
No. I'm showing. At page.
You are Mr. Karji.
Yes. Apurva Karji. That's I'm showing.
Karji to naam hi pachi.
My lord, allegation against him, he has siphoned on 52 lakhs from one bank.
At page 25. As page 25. Kindly see.
Not a specific allegation.
25 of my application.
Page 25.
Yes. Of my application.
So your name is there.
Yes, I was charged sheeted.
No, you are charge sheeted, but like 16.18 specific allegations are there against you. We are wanting that. Your name is there. There is no doubt about that. Nobody is disputing that.
Yes.
Brief facts of the case. Where have you been mentioned?
Lordship, page 34, text 2.5. May I read it out?
34.
Of his application. That further investigation is revealed from all the above charge that Sunil Kumar Sarkar, Shanot Kumar Rai, Asim Kumar Bormon, Apurva Karji, and Nikhilesh Datta, the founders of Messrs. Unifying Earth Share Brokers Limited and other sister concerns. They were the common named persons in every sister companies. They were already running their separate entity in their field, while visibly Unipay, Royal International Trading, and Creative Tools and Travel. They have decided in a meeting to launch a new investment company, collect funds from public by alluring them with bright future prospects. And he has misappropriated around 52 lakhs in his own name.
No, Mr. Mujumdar, there is the allegations against him are not more grave than the other person who has been released.
I can place it. I place the investigation report before my lord.
No, but the charge, we go by the charge sheet. We need not go into the investigation report at this
My lord
stage.
can very well look into that.
We can look into, but we don't want to look into the
He has taken out 52 lakhs from the company's account to his own account. He received it in his own name.
How much did the other person who is on bail to take out? Must be similar, something similar.
No, my lord. I've just. My lord, I have to take out, my lord.
No, Mr. Mujumdar, other person has got bail, he is entitled to bail, no.
Lordship, now.
If this was the first application, we
No,
might
my-
have been stricter, yes.
Let me be candid, but then the trial will never come. Never. What you want?
Never comments.
No, why?
If he's released on bail.
My lord, he will just cross the border. He will just cross the border.
Strange argument, Lordship.
This is actually, no, this is a strange argument, because Sunil Kumar Sarkar, he has not crossed the
No, my
border,
lord.
why should this
Sunil-
person?
Then, my lord, allow me to come back tomorrow. I will place Sunil Kumar Sarkar's 164 statement.
We'll go by the charge sheet, your charge sheet. Learned counsel for the petitioner argues that a co-accused person on similar footing has been enlarged on bail, pushed up. Further, comma, it is contended that charge sheet has already been submitted and the investigation is over, pushed up. Hence, comma, the petitioner ought not to be incarcerated further. Push up next para, learned Deputy Solicitor General seriously opposes the application for bail and submits that one of the other accused persons was released and was refused anticipatory bail even after the co-accused person was granted bail by a coordinate bench. Pushed up. Further, comma, the nature of the allegations are that the petitioner and the other co-accused were engaged in a Ponzi scheme. Pushed up, it is submitted that after the CBI took over investigation in the year 2021, comma, the investigation was expedited and the petitioner has been arrested. Pushed up, in the event the petitioner is released on bail, comma, it is submitted, comma, it would directly affect the trial. Pushed up further, comma, it is submitted that the petitioner embezzled huge sums of money and the involvement of the petitioner is grave. Pushed up next para. Upon considering the competing orders, comma, one granting bail and one refusing anticipatory bail to two of the co-accused persons, comma, we are of the opinion that the coordinate bench which refused the grant of anticipatory bail to a co-accused person on August 16, 2023 did not take into consideration the fact that another co-accused had been released on bail the previous month, that is on July 11, 2023. Pushed up. It does not transpire from the said order of refusal of anticipatory bail that such argument was made on behalf of the petitioner therein. Pushed up. In the order dated July 11, 2023, comma, the other coordinate bench observed that upon giving due consideration, comma, the bench was satisfied that in course of investigation, sufficient incriminating materials have been collected by the investigating agency and that it is not a fit case for custodial trial. Pushed up. Upon a careful perusal of the charge sheet, comma, we find that the petitioner is on an exactly similar footing as the other co-accused person who was granted bail on July 11, 2023. Pushed up. Next para. Hence, comma, the same logic as was furnished by the coordinate bench while granting bail to the other co-accused, namely Sunil Kumar Sarkar, is also applicable to the present petitioner. Pushed up. Next para. Despite the nature of the allegations made, comma, since investigation has already been concluded and charge sheet has been filed, along with a supplementary charge sheet, comma, we are of the opinion that the same benefit as extended to Sunil Kumar Sarkar, a co-accused, comma, ought to be granted to the petitioner, comma, if not otherwise, comma, on the ground of parity. Accordingly, CRM DB 458 of 2023 is allowed, thereby granting bail to the petitioner on condition that the petitioner usual conditions to the satisfaction of which court?
CJM Alipurduar.
CJM Alipurduar.
May please let me insert the default clause.
In default of any of the conditions stipulated above, comma, the petitioner, the bail granted to the petitioner shall be cancelled upon giving an opportunity of hearing to the petitioner.
Instead of CJM, it will be SCJM. Kindly. SCJM, additional jurisdiction. Great.
38 years.
My lord, allow me 1 minute.
Yes.
My lord, last two circuits.
Tomorrow
circuits. So let it come in the next circuit, my lord. He's not at all serious with this, with the given.
Next sec,
Tomorrow.
My lord,
why
next
tomorrow?
Tomorrow I have some lack of preparation. Tomorrow I will done, my lord. Tomorrow. Well, I have done.
My lord, you can wait, my lord. My lord will see the water sheets. My lord, my lord, let it come on Tuesday, we'll do it. Every circuit.
Learned counsel for the petitioner seeks an adjournment for a day. Learned Deputy Solicitor General submits that since the matter has been adjourned on several circuits on the prayer of the petitioner, comma, the same may be adjourned till the next circuit in order to enable the CBI to properly assist the court. Full stop. Accordingly, the matter is adjourned till the next circuit. A reasoned order of adjournment, Mr. Mujumdar.
My lord, I do not comment on the judicial.
Yes, next.
Grateful, my lord, with your leave.
My lord, I'm for the petition. My lord, the allegations are under NDPS Act, my lord. Petitioner is behind custody since long, my lord, 44 days, my lord.
Stage of trial?
My lord, out of 11 witnesses, 4 has already been examined.
Will grant bail, 844 days. Learned counsel for the petitioner submits that the petitioner is in custody for 844 days, full stop. Upon query, comma, learned counsel for the state contents that out of 11 witnesses, 4 have already been examined, full stop. The prayer for bail is opposed by the state, full stop. However, comma, keeping in view the long period of incarceration of the petitioner, we are inclined to grant bail. Accordingly, CRM NDPS 722 of 2023 is allowed, granting bail to the petitioner. Usual conditions 10,000, 2 sureties like amount to the satisfaction of Special Court NDPS Siliguri.
Not kindly add one line, my lord. Not a huge quantity of brown sugar is involved in this case.
Acha, learned counsel for the state যেখানে opposes বলেছি
12,000 grams.
কি বলেছি কথাটা একটু বলুন
1200.
The state content that out of 11 witnesses, 4 have already been examined. But therefore, they on this almost private statement.
comma
Much above the commercial point.
on the ground that the seized contraband articles were much above the commercial quantity. Yes.
If you oblige, well.
Sixty bottles of fentanyl. What has happened after February?
Petitioner is custody for 1 year and 9 months. Last election on 4/9/2023. Yes, madam.
4/9.
Yes, yes, madam. Madam.
Oh,
One point regarding delay sending sample. This point was never taken. I have annexed all the orders on section 52. Compliance of section 52 not taken into consideration. Never, never.
Probably not at this.
Never, madam. This point. Madam, matter seized on 12th February 2021. An inventory was prepared on 27th December and it was sent on 3rd January 2022. But there is delay.
That is not affecting him.
Madam, this not.
That is not affecting him in any
Only
manner at this
60
stage.
bottles
That
and
is
1
trial
9
is
month in
widest.
custody. Madam, can you see the order?
You get the widest opportunity to agitate these particular
Madam, never
things in
this
the
point
trial.
into
That is the
consideration.
best place to be determined.
Never any of the counts not taken.
Learned counsel for the petitioner argues that the provisions of section 52 capital A of the NDPS Act was not complied with. Full stop. It is contended that the petitioner is also in custody for 1 year, 9 months. Full stop. Next para. The prayer for bail is vehemently opposed by the state. Full stop. Learned counsel for the state points out that the prayer of bail of the petitioner has been rejected on several occasions, comma, lastly, as recently as on September 4, 2023. Full stop. It is further denied that the provisions of section 52 capital A of the NDPS Act were contravened. Full stop. Next para. We find from the annexures to the application that the petitioner's prayer for bail was rejected on February 27, 2023 on the ground that the petitioner does not stand on equal footing as a co-accused who was granted bail comma, particularly since the narcotics were recovered from the petitioner. Full stop. In the order of refusal of bail dated September 4, 2023, comma, we find that the coordinate bench held that the contraband substances obtained were clearly above commercial quantity and the rigors of section 37 were applicable. Full stop. Next para. We do not find that any whisper of contravention of section 52 capital A was made even before the coordinate bench on September 4, 2023. Full stop. We are convinced that nothing substantial has occurred in between September 4, 2023 and the present date to justify grant of bail to the petitioner, comma, which would virtually tantamount to reversing the order of the coordinate bench. Full stop. Accordingly, CRM NDPS 741 of 2023 is refused, dismissed.
41, my lord, I am for the petition. May it please your lordships. My lord, this is, my lord, also a bail application, my lord, under the provisions of NDPS Act. My lord, the seizure was affected, my lord, at the new Kuch Vihar railway station platform number 3 in the broad daylight. But my lord, surprisingly, no independent witness could be found by the investigating agency. And my lord, even the 41B has not been complied with. Lordship, my lord, page number 15 to 17 is the memo of arrest of my application. Your lordship will find the column 10 as blank for all the petitions. Lord, charge sheet has been submitted, my lord. Trial is yet to begin.
Yes, what do you say? 41B. 41B, no independent witness. Right. We are recording there. Learned counsel for the petitioner submits that the provisions of section 41 capital B of the Criminal Procedure Code was violated. No independent witness signed the memo of arrest. Full stop. That apart, comma, the recovery was allegedly made from a railway platform in broad daylight, but no independent witness could be produced but no independent witness signed the documents of arrest. Full stop. It is, comma, thus, comma, submitted that the petitioners ought to be enlarged on bail. Full stop. Learned counsel for the state opposes the prayer for bail and argues that huge commercial quantity of contraband was recovered from the petitioner. Full stop. Next para. We find that in the present case, comma, in view of contravention of section 41 capital B of the Criminal Procedure Code, comma, a prima facie presumption is created to alleviate the rigors of section 37 of the NDPS Act. Full stop. Hence, comma, since charge sheet has already been filed, comma, the petitioners ought to be granted bail. Accordingly, CRM NDPS 743 of 2023 is allowed. Usual condition, each, our surety may be common for all the petitioners to the satisfaction of Special Court NDPS Kuch Vihar.
Grateful. Trial is yet to begin.
Second October, which court will take even? Even Nathuram Godse's evidence was yes. Must have been wrong.
I am for the petition. Now, Lordship, not on merit, this case relates to NDP. Now, the Lordship, kindly see the page number 19, the status report.
What is SDT?
Settling date of trial. Now, my lord, kindly see, I was arrested on 2nd December 2021. Charge sheet was filed on 11th May 2022. since 11th May 2022 to 27th January 2023, 626 days lapsed to supply the copies. There is no contribution from my end, your lordship. I'm repeating my word, 626 days needs to supply the copy. Now can you see, your lordship? 19th May 2023, charge framed. 19th July 2023, fixed for settling date of trial. 5th August 2023, for fixed for settling date of trial. Last date was fixed on 29th. That is also fixed for settling date of trial. The next date is fixed for 30th September 2023.
Your period of custody is?
Period of 660 days.
Yes, what do you say? On period of custody, we are granting bail. Yes.
I have annexed the status report obtained from the e-court service.
Will record your opposition 500 kg of gaja, huge quantity, etc.
No.
What? No.
There is no.
Then we won't record that.
Lordship, earlier
Eight witnesses have been examined.
What do you say? What do you say? 8 witnesses, I think you have wrong CD. Till to the date of fixed for settling date of trial.
Wrong CD?
Lordship, give me 1 day.
No.
Lordship, the status report I obtained from the e-court service, and he said 8 witnesses.
Wrong CD is very risky. Wrong CD. No.
Before Lordship, give me just.
Tomorrow top better. Please repeat what you said.
Lordship.
Particularly 626 days and 660 days. These two, please repeat.
Lordship.
Yes. কালকে টপে রেখে দিও। No. Yes.
Lord, I am for the petitioner in this matter.
Yes, Mr. Laksam, come here. Yes.
Lord, this Lord also relates to the NDPS Act. Lord,
Page 14 is a co-accused.
page 14, Lord. Yes, co-accused.
Same footing.
Not same footing, Lord.
Achha,
The case transfers, Lord, two co-accused persons were first apprehended. FIR was lodged.
Right.
And on the basis of statement of one of the co-accused persons, Lord, raid was conducted allegedly in the house of the present petition. Lord, they made certain seizures from the house of this petitioner. And it is mentioned in the seizure list that the said seizure was done from the bedroom of the present petitioner. However, Miller, in the charge sheet, they says that the petitioner was fleeing away and he was chased, and Miller, thereafter the seizure was made from him. So, Miller, the investigating agency, Miller, itself contradicts its case.
No, you are fleeing, but it was recovered from a bedroom, maybe.
No. In the charge sheet, it said, Miller, he was fleeing away and then he was apprehended, and from him it was recovered.
Show us that portion.
Lord, I had two more points, Lord. Anyway,
Just let us start with this.
yes,
Column number 17, my lord.
column number 17 in the charge sheet. Lordship will find, leading to his statement as shown and identified by him, I conducted raid in the house of one Vinod Rai. Lordship has found, Lord.
Which page?
Lord, charge sheet, internal page number. Lord, last page of the brief. Second last page. Starts from column number 17, bottom part.
Yes, which portion? Column number 17, yes.
Yes. Lord, fifth line. Lord.
What is your name?
My name is Vinod Rai.
Yes.
Lord, it says, leading to his statement as shown and identified by him, I conducted raid in the house of one Vinod Rai, son of so-and-so, resident of so-and-so, in assistance with the police of Sevak PP under Karshan PS on 31st night. Scene police said Vinod Rai was trying to flee away with backpack styled as Parity. We could detain him. Then I introduced him, my identity and so-and-so, conducted search of his body and backpack. And we have information that he is possessing some contraband drugs and psychotropic substances. But if he wants presence of a gazetted officer or executive magistrate during such, I can arrange. And my lord, thereafter, my lord, from the backpack, they say, then it
Right,
must-
right, right.
Yes.
Backpack, yes.
Yes.
The complaint and where was it mentioned that from his bedroom? Caesar.
In the Caesar list. In the
Right.
Caesar list. My lord, the 51A, 52A was done, my lord, after 15 days of the said Caesar. And the samples were sent after 22 days of the Caesar, my lord. I am in custody, my lord, around 230 days. My lord, charge sheet has been submitted. My lord, co-accused persons are on bail. On whose statement, my lord, this raid was conducted.
It is true that in the Caesar and in the charge sheet, my lord, whatever my learned friend says is true, because in the Caesar it is mentioned from the bedroom, and in the from the memo also memo of arrest, my lord, he was arrested from that particular spot at Parijat Nagar, Sivok under Sivok, my lord, police station, my lord.
Learned counsel for the petitioner submits that the petitioner was arrested on the statement of co-accused. It is argued that although the Caesar list shows that the seizure was made from the bedroom in the house of the petitioner, the charge sheet mentions that the seizure was made from the person of the petitioner, to be more precise, from a backpack carried by the petitioner. That apart, there is violation of section 52 capital A of the NDPS Act, inasmuch as what was the gap between the seizure?
50 days.
Inasmuch as there was a gap of about 15 days after seizure. Moreover, the sample was sent for examination 22 days after the seizure. It is argued that such circumstances create a doubt and alleviate the restrictions of section 37 of the NDPS Act. Learned counsel for the state opposes the prayer for bail. However, we find from the circumstances that the restrictions of section 37 are not applicable in respect of the petitioner. Accordingly, CRM NDPS 746 of 2023 is allowed, thereby granting bail to the petitioner. Satisfaction of special court NDPS?
Kalimpong, my lord.
Kalimpong. Market Act, 10,000 rupees.
Grateful to your lordship.
Yes, please.
May I please, my lord?
No CD.
No CD. Please come back tomorrow then.
Yes.
Not.
My lord, I beg to submit before your honor that on the last 18 lordship, 18 September CD was there.
CD was there?
Yes. On the last occasion, CD was received by this office.
My lord.
But it was submitted that CD was not received. I cannot understand what is going on.
Yes.
My lord, actually, case diary, original case diary is lying with another state panel advocate. Actually, there are two petitioners. Separately, they filed. That is the problem, man.
At the first time when
Petitions means they have filed separate applications.
Yes. But case diary is one.
Yes, but if it is with you, why don't you produce it?
Yes, my lord.
If it is with you, why don't you produce? Not you personally. I mean, if it's there in the state.
But it was fixed on another date, my lord. This is the problem.
I honestly pray before my lordship to receive the CD by the PP on the tomorrow.
Tomorrow we will collect the CD and tomorrow we will.
It is order record. Learned counsel for the petition. Learned counsel for the state seeks an adjournment on the ground of non-availability of CD. Learned counsel for the petitioner submits that the CD was obtained on September 18, 2023, but it is unexplained as to why the same is not being produced. Learned counsel for the state explains that there are separate applications by different co-accused persons in connection with the same offense, for which the CD is at present lying with a different learned counsel from the panel of the state. Be that as it may, let the matter be listed tomorrow fairly at the top of the list when the state shall be present with the CD.
Grateful.
Tomorrow fairly at the top.
Grateful.
Please give your appearances. Ask him to give his appearance.
বাবু ও দিলীপ বাবু তোমার অ্যাপিয়ারেন্সটা আইটেম নাম্বারটা তোমার নামটা লিখে দাও
Lordship, actually, it so happened, actually, I made a mistake. I apologize for that. I'm ready with the matter now.
Which matter?
that was which was fixed on top of the list too.
Why am I mentioning this? Because I might leave tomorrow. Not sure yet.
We have passed an order in open court.
No.
Tell her to give the item number, please.
42 years.
42 ফাইলটা বার করা যাবে কালকে টপে ফিক্স হয়েছে দেখো তো
Please renew your submission.
I have renewed my submission.
660.
660 and 626.
Yes.
626 since the date of submission of charge sheet to supply of copy, and 660 days I am in custody.
We are granting then
Lordship.
Learned counsel for the petitioner sub.
No, Lordship, one second. One second. One second.
My earlier plan I have not pressed. That is my.
Wait.
Now you are missing.
You said you are ready, you are looking through the papers.
I am ready.
Then move it.
I am ready, Lordship.
Yes, what is your contention?
12th of October speaks for examination of PW 9 and 10.
No.
The trial has progressed a lot. This is the judicial order.
Lordship then fixed on tomorrow, Lordship fixed on tomorrow, I will show.
Now, no.
Is it wrong city this is? No. Kalimpong not Jalpaiguri. What's the city you are placing? This case relates to Jalpaiguri. You are placing a city of Kalimpong. What the hell you are doing?
Shubin is.
Cool, Harjinder Singh.
45, that is 45.
45, but that is 42. What you are doing?
Harjinder Singh, I don't have the.
45.
I apologize.
Maybe fix on top of the list tomorrow. You must active extra action is because I am on the law, conducting law on the child.
I apologize.
কাল টপে জ্যাম ছিল হ্যাঁ
Lord, in item 45, my lord, I have for the petition. Made please your lordships.
Yes.
Lord, this matter, my lord, also relates to the case under an NDPS Act. My lord, there is a clear violation, my lord, of section 42 subsection 1, which, my lord, categorically enshrines, my lord, that no seizure, search and seizure could be done, my lord, after the sunset and before sunrise. My lord, here, my lord, the search and seizure was conducted at 21:15 hours to 22:45 hours. My lord, without any special reasons being recorded by the concerned investigating officer. And my lord, surprisingly, my lord, the independent witness who has signed my memo of
no that sunrise sunset rule is applicable here also in NDPS.
Yes, my lord, in 41.
That is in respect of ladies probably.
No. That is, my lord, section 50 subsection 6.
Right.
Not 42 subsection 1 says, my lord, after sunset and before sunrise, my lord, it
Of
cannot.
CRPC.
Of NDPS Act.
42.
41 subsection 1. Sorry, 42 subsection 1. my lord. Yes.
Trial has progress.
My lord, 42 subsection 1 starts with that clause. It says, my lord, may between sunrise and sunset it could be done. 41 টা বড় না, 41 টা দেখা।
42.
42 subsection 1.
Yes.
Lord, may I read it out, my lord? Lord, any such officer being an officer superior in rank to a peon, sepoy, or constable of the departments of Central Excise, Narcotics, Customs, Revenue Intelligence, or any other department of the central government, including paramilitary force.
Second proviso probably.
Yes. So, my lord, there is a specific bar under the act.
Yes.
And my lord,
it appears from the records that sunset.
Yes, in the FIR itself, my lord, they have stated. And my lord, surprisingly, my lord, one person, my lord, he has signed my memo of arrest, but he has not witnessed the search and seizure procedure, my lord. His name does not transfer there. as a witness, but his name appears in my memo of arrest, my lord. So, my lord, that is also, my lord, contravention of section 41B, my lord.
Yes. Anything else? Yes.
No, no. 6. My lord, 6 witnesses examined, 9 more remaining.
Learn- You're in custody for how
1
long?
year, 20 days in custody.
Learned counsel for the petitioner contends that the petitioner is in custody for 1 year, 20 days.
Yes.
Full stop. Next para. Further, comma, there was a gross violation of section 42 within bracket 1, comma, second proviso of the NDPS Act to the extent that even from the FIR, it transpires that the arrest was effected long after sunset. Full stop. Next para. That apart, comma, it is argued that the person who signed as a witness in the memo of arrest is not a part of the signatories as witnesses to the seizure list. Full stop. Such discrepancy itself vitiates the process of seizure and arrest, comma, it is argued. Full stop. Next parallel, counsel for the state opposes the prayer for bail and submits that the trial has progressed substantially and shall be concluded soon. Full stop. As such, comma, bail ought not to be granted to the petitioner at this stage. Full stop. We find that the petitioner is already in custody for more than 1 year. Full stop. That apart, comma, the petitioner is justified in arguing that the provision of second proviso to section 42 within bracket 1 of the NDPS Act was prima facie vitiated since the arrest was effected long after sunset. Full stop. That apart, comma, keeping in view that the petitioner is in custody for quite some time and custodial trial is not necessary, comma, we are inclined to grant bail to the petitioner. Accordingly, CRM NDPS 750 of 2023 is allowed. Usual conditions to the satisfaction of the Special Court NDPS Act at Kalimpong.
Yes.
At Kalimpong.
My lord, the search and seizure was effected along with the arrest, my lord, because that is the 42 says, my lord.
Search and seizure. যেখানটা বললাম seizure and arrest, search and seizure.
Great.
Actually, item number 153, his father is seriously ailing and doctor advised him to go into Chennai for use stent in his chest. But the matter is lying in the 153. If possible, subject to your lord's convenience, it may be fixed within 10, your lordship, tomorrow. Because one of his son already expired and another son incarceration. I have the documents to show.
কাল 153 টা উপর দিকে দিয়ে দিস। Yes.
Oblige you.
Lordship, item number 256, Lordship. কি হবে স্যার? আমাদের মামলা
নেই? হ্যাঁ আছে, এই তো আছেন তো। Yes, Mr. Basu, yes. Petitioner নেই তো। অন্য লিস্টে no petitioner is online.
Yes, yes.
Oh yes, 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 Mr. Shen.
Yes,
What is your
my lord.
instruction?
Yes, my lord. My instructions that, my lord, this email of 11 September, this will be withdrawn, my lord, in the course of this day. The same person, that is Mr. Pradyana Pinto, who has issued this email of September 11.
Yes.
He will issue another email today, withdrawing this email of 11 September.
Mr. Sarkar will drop the content unnecessarily.
My lord, may I make one prayer only? My lord,
Yes.
my lord, very grateful to Mr. Shen, my lord, for making this gesture. My only request is, my lord, if it only can be kept pending till next week, my lord, let the trading resume. And upon, my lord, an affidavit being filed that the letter has been withdrawn, may the contempt be dropped. It only subject to what my lord feels, my lord. If my lord feels
My lord,
otherwise, I will not stand in the way.
if my learned friend receives the email in the course of the day,
No, Mr.
then
Shen, he is right.
probably
Actually,
affidavit may not be necessary.
No,
If
no,
he
even
does
then,
not
Mr.
receive the
No,
email,
affidavit may not be necessary, but will require. I mean, we'll keep it pending. The content will keep pending. We'll record it.
yes.
Learned
Yes,
counsel appearing for the alleged contemner submits on instruction that the author of the email dated September 11, 2023, namely one Pradnya Pradnya Pinto, PINTO, shall withdraw the said email during the course of the day by sending another email. Full stop. Next para. It is thus, submitted that the contempt may be dropped. Full stop. Next para. Learned counsel for the petitioner submits that final orders may be passed only after such email is issued and the email dated and the communication dated September 11, 2023 is actually withdrawn. Full stop. In view of such submissions, let the matter be adjourned till September 26, 2023, when it will be listed before the principal bench under the heading to be mentioned.
Very well.
Grateful, my lord. Grateful.
Obliged. Very obliged.
Auditor, 26 তারিখ মেইন বেঞ্চে প্রিন্সিপাল বেঞ্চে কিন্তু টু বি মেনশন হেডিং এ দিয়ে দিতে হবে, এটা একটু তুমি ব্যবস্থা করে দিও। থ্যাংক ইউ।
Grateful, lord. Grateful.
Item number 1 and 2.
Yes.
But the subject matter of challenge. Subject matter of challenge is an order of transfer, which is after the promulgation of the rule is statutorily provided. Prior to the rule, there was no provision for transfer, and somebody was going to be transferred. These that those litigations are there, and that the scam is there. But here, a read petition has been filed by an assistant teacher of a school where I was an assistant teacher. One point of time prior to my transfer to another school, and thereafter I should not say promoted, as it was advertised. I applied considering my ability. Interview, I was given the post of headmaster, headmistress. Thereafter, I applied for transfer. Transfer has been granted. That has been challenged. Ikramul, sound up kar. Now, my lord, my first point will be before my lord, the locus standi of the writ petitioner to challenge the order of transfer passed in my favor. But I will request your lordship to hurriedly go through the pleadings in the petition. If your lordship kindly. take up the petition. I have been told, my lord, the paragraph 4 has been placed already, while, my lord, the other day. My lord, paragraph 4, allow me to repeat it. It is submitted, your petitioner is not at all interested to oppose the action of the respondent for filling up the post of headmaster in the school in question. Means the schools where I was transferred. The grievance of the petitioner is against the private respondent who managed to get the transfer order from the School Service Commission by ignoring all provisions of law. As such, your petitioner approached this honorable court, drawing attention to the illegality committed by the School Service Commission, transferring the private respondent from Birpara Girls High School to Sri Guru Vidya Mandir High School, which is not at all permissible in the IO. But this is the paragraph which highlights that he has no grievance. I have checked the Malor subject to opposing by my landed friend and the my lord. In the entire petition, he has never said that what is the harm caused to him. What is the legal right he has, which has been infringed by a statutory authority. My lord, we normally say that the locus standi in the writ petition has undergone a sea change. In a judgment of the apex court also, he said it has gone a sea change.
Yes.
My lord, let us consider, my lord, what is the sea changes. The basic structure of the constitution is still same, which was there when it was promulgated. But I will request your lordships to once allow me to place Article 226. A very fundamental thing, my lord. I used to trouble your lordship.
Yes.
My lord, may I read with your lords? Notwithstanding anything in Article 32, every High Court shall have the power throughout the territories in relation to which it exercises jurisdiction to issue any person or authority, including the appropriate cases, any government within those territories, directions, order or writs, including a writ in the measure of habeas corpus, mandamus, prohibition, quaranto, and certiorari, or any of them. Now, my lord, the main I am giving thrust on that. For the enforcement of any of the rights conferred by Part 3 or any other purpose. My lord, Part 3 is fundamental rights. If you lordship want to look once, my lord, index will suffice. What
No, Part 3 is fundamental rights.
Fundamental rights, my lord. One is right to education. This is a field of education. The fundamental right is right to education under Part 3. Now, my lord, I go back. It says for conferred under Part 3 and for any other purpose. This and for any other purpose is akin to Part 3. So I give an instance, my lord. Order 47.
Yes, yes.
But
Obvious instance. Obvious.
Any other. There is a judgment, my lord knows, that is any other is akin to 47, cannot divorce that. So up till now, constitution framers make it as it is, that if there is any violation of Article Part 3 of the Constitution, then and then only it can be said a right has been infringed, which is a legal right, has been infringed by an authority, statutory authority. But considering this, my lord, I will cite 2 or 3 judgments for your lordship consideration, because on that date, my lord, your lordship was heard Mr. Bari without going through this point. My lord, I will start with AIR 1964 Supreme Court. But kindly see the strength of the judge. 5 judges bench. AIR 64 Supreme Court 685. Oh my God. But kindly come to paragraph 8. This is a 5 judges bench, my lord. Why I am mentioning this? I have something to say about the strength of the bench. On the merits, the position is absolutely clear. Under Article 226 of the Constitution, the jurisdiction of the High Court is undoubtedly very wide. So this is the sea change. The Constitutional bench is changing the law. Appropriate writs can be issued by the High Court under the fundamental right, under the said article, even for the purpose other than the enforcement of the fundamental rights. And in that sense, a party who invokes the special jurisdiction of the High Court under Article 226 is not confined to cases of legal innovation of his fundamental right alone. But though the jurisdiction of the High Court under Article 226 is wide in that sense, the concluding words of the article clearly indicates that before a writ or an appropriate order can be issued in favor of a party, it must be established that the party has a right and the right is illegally invaded or threatened. But may I pause here for a moment? Still, the constitutional bench making wide that the law has been changed, see change, even then your injury of the legal right is a sine qua non to invoke the jurisdiction of this court. I say on the facts of this case, there is no statement, even there is nothing, even if there is no, I not go to the strict compliance of the pleadings, even there is no prejudice or any right has been infringed by the statutory authority. Well, I will show you, let's see how the law changes and how far it has been changed. Well, next judgment I want to rely, AIR 1977 Supreme Court 276. This is Honorable Three Judges Bench, led by Justice A.N. Ray, as it of the universe. Kindly come to paragraph 9.
Yes.
The High Court rightly dismissed the petition. It is elementary, though it is to be restated, that no one can ask for a mandamus without a legal right. There must be a judicially enforceable right as a legally protected right before one suffering a legal grievance can ask for a mandamus. A person can be said to be aggrieved only when a person is denied a legal right by someone who has a legal duty to do something or to abstain from doing something. Laws of all cities of England has been quoted and said the same line. This is Honorable Three Judges Bench. Then, my lord, I will SCC paragraph. My lord, next is, my lord, 1977 two Supreme Court cases. Same bench, the Three Judges Bench, my lord, reiterating the same thing.
Page 148.
Page 148, paragraph 7. The sole question that requires to be determined in these appeals is whether the appellant could maintain the aforesaid writ petition. It is well settled that though Article 226 of the Constitution in terms does not describe the classes of persons entitled to apply thereunder, the existence of the right is implicit for the existence of the extraordinary jurisdiction by the High Court under this article. It is well established that a person who is not aggrieved by the discrimination complained of, here the discrimination point was taken, discrimination contempt of, cannot maintain a writ petition. The constitutional validity of the abolition of the act abolishing all, this is on the facts of this case. The first part is the same, identical, reiterated by the Honorable Three Judges Bench. Now, I come to my lord. Lord, let us come to 2002. Sorry. Page 33.
Please give the citation for Mr.
Yes, he is here. His junior is here. 2002, one Supreme Court cases 33. Paragraph 38. The deputy solicitor is saying that you are gapping so much. 77, then 2002. Page 33, paragraph 38. Yes. There is no dispute. As you might have got it.
Yes.
There is no dispute regarding the legal proposition that the rights under Article 226 of the Constitution of India can be enforced only by an aggrieved person, except in the case where the writ prayed for is for habeas corpus or quo warranto can be done by anybody, any public. The existence of the legal right of the petitioner, which is alleged to have been violated, as the foundation for invoking the jurisdiction of the High Court under the aforesaid article. The orthodox rule of interpretation regarding the locus standi of a person to reach the court has undergone a sea change. With the development of constitutional law in our country, and the constitutional courts have been adopting a liberal approach in dealing with the cases for dislodging the claim of a litigant merely on hyper-technical grounds. If a person approaching the court can satisfy that the impugned action is likely to adversely affect his right, which is shown to be having source in some statutory provision. The petition filed by such a person cannot be rejected on the ground of his not having the locus standi. In other words, if the person is found to be not merely a stranger, having no right whatsoever to any post or property, he cannot be non-suited. So there are two things. One is locus standi, one is aggrieved. Only locus standi you will not do. You have to show that you are aggrieved by the action which is legal injury to you. Then, my lord, let us come to 2013. 2013, 4 Supreme Court cases, 465. Paragraph 9.
Thank you.
In this judgment, my lord, the court, the division bench, the Supreme Court division bench is categorized two things. One is person aggrieved by on seat, and another is, your lordship can come to the next page. It is at page 478, paragraph 18. The nomenclature is locus standi. So it has two components. We are concerned now only, my lord, both. Let me place paragraph 9. It is a certain legal proposition that a stranger cannot be permitted to meddle in any proceeding unless that satisfies the authority court that he falls within the category of aggrieved person. Only a person who has suffered or suffers from legal injury can challenge the act, actions, order, etc. in a court of law. A writ petition under Article 226 of the Constitution is maintainable either for the purpose of enforcing a statutory legal right or when there is a complaint by the appellant that there has been a breach of statutory duty on the part of the authorities. Therefore, there must be a judicially enforceable right available for enforcement on the basis of which the writ petition is resorted to. The court can, of course, enforce the performance of a statutory duty by a public body using its jurisdiction at the behest of a person, provided that such person satisfies the court that he has a legal right to insist on such performance. The existence of such right is condition precedent for invoking the real jurisdiction of the courts. It is implicit in the exercise of such extraordinary jurisdiction that the relief prayed for must be one to enforce a legal right. In fact, the existence of such right is the foundation of the exercise of the said jurisdiction by the court. The legal right that can be enforced must ordinarily be the right of the appellant himself, who complains of infraction of such right and approaches the court for relief as regard the same. This judgment was quoted. Then A. Legal right means an entitlement arising out of a legal rules, entitlement. Thus, it may be defined as an advantage or a benefit conferred upon a person by the rule of law. The expression person aggrieved does not include a person who suffers from a psychology or an imaginary injury. A person aggrieved must therefore necessarily be one whose right or interest has been adversely affected or jeopardized. In such and such judgment, a similar view was taken by this court, observing that if a person claiming relief is not eligible as per requirement, then he cannot be said to be a person aggrieved, leading to the election of the person. Then, my lord, this judgment was 2011-7 also SCC also relied upon. Then, my lord, paragraph 13. This court, even as regard the filing of a habeas corpus petition, has explained that the expression next friend means a person who is not a total stranger, would not necessary for our purpose. This court has consistently cautioned the courts against entertaining public interest litigation. This is also public interest litigation. This is not our case. Even then, what is saying? Interest litigation filed by unscrupulous person, as such, middles do not hesitate to abuse the process of court. The right of effective access to justice, which has emerged from the new social rights regime, must be used to serve basic human rights. These are also on that point. So we are not concerned. Paragraph 15 also public interest litigation. This is not a case of public interest litigation. So this is the view even in Malad 2013. Now, my lord, I will show to your lordship. The judgment relied by my landed friend is of 2000. I will distinguish that, my lord, after I cite this judgment. 2020, 12 Supreme Court cases. Page 70, paragraph 25.
Page 87.
page 70, my lord. কি ভুল করলাম 87 কি রে লিখছেন আপনি ভুল লিখেছি আমি হ্যাঁ just a minute my lord, give me
Yes.
page time. Yes, is my mistake. I have the wrong page. Para 25. For the aforesaid facts and reasons, the challenge made by the appellants to the appointment and absorption of respondent number 4, he has transferred. Can you read that as transfer? For the aforesaid facts and reasons, the challenge made by the appellant to the appointment and absorption of respondent number 4 is not tenable, and they have no locus standi in the matter. It may be relevant to refer to the observation of this court. This is my lord of 76(1) has been relied upon and says that the relied upon by the High Court holding that unless injury is suffered personally, the person cannot be said to be aggrieved and has no locus standi. My lord, the 77 Supreme Court has been relied upon, paragraph 48. In the light of the above discussion, it is demonstratively clear that the appellant has not been denied or deprived of a legal right. He has not sustained injury to any legally protected interest. In fact, the impugned order does not operate as a decision against him, much less does it wrongfully affected his title to something. He has not been subjected to a legal wrong. He has suffered no legal grievances. He has no legal peg or a justiciable claim to hang on. Therefore, he is not a person aggrieved and has no locus standi to challenge the grant of the no objection certificate. Here, my lord, can I read this as transferred? So, my lord, even after the change, the basic structure I have read before your lordship 226, language 226, and starting from 64 Supreme Court constitutional bench, whatever changes has been made, that everywhere, my lord, the judgment of 64 Supreme Court has been echoed, excepting, my lord, the judgment of 2000 volume 7. I will place that. Probably it has been handed over to my lord.
Yes.
2000 volume 7 Supreme Court cases 552.
Do you have any copy of this?
That I don't
No, you can take my copy and give me the paragraphs. So I'll take note of that. I won't be passing orders immediately.
No, 13-14 he has relied on.
Yes.
My lord, here I will. He has relied on paragraph 14 mainly. In paragraph 14, there is a finding that feeling that his initial petition is not maintainable because he is a third party to a tender of foreign legal offshore. In the reply, he has taken a point that yes, I am agreed because I am the resident of that locality, so my right infringed as a resident of that locality. He has said something. This is one distinguishing feature. Apart from that, I will kindly allow me to submit that these are the judgment. This judgment is of honorable 2 judges. Without considering, my lord, any of the judgment I have shown to your lordship, my lord, the constitutional bench, I submit there is no change. Whatever has been changed, the new concept adopted is public interest litigation. That is the only change of locus standi. But so far as the personal grievance is concerned, in a 226 petition, so much word has been said that there is a C change, but in fact, I tried to satisfy my lord, starting from 64 till 2020, view is echoed, accepting this judgment, where also the court has taken view that knowing fully well, realizing that his writ petition may not be maintainable, in reply he has taken the point. This is, my lord, so far as this locus standi point is concerned. I will cite one judgment. It is on the for this proposition that if the larger bench judgment is holding the place, then, my lord, the smaller bench judgment has no role to play. This is, my lord, 1983 2 Supreme Court cases. This is, my lord, I was thinking whether cited judgment report, my lord, or not. This is so established proposition. My lord, if your lordship kindly, 1983 Supreme Court cases 344, para 14. Here, my lord, question of death sentence. There was a Supreme Court judgment earlier. It says death sentence is constitutionally valid and permissible within the constitutions of the rule of certain court judgment that judgment was considered. This has to be accepted as the law of the land. We do not, all of us, share the views of every one of us. And that is natural because every one of us has his own physiology of law and life, molded and conditioned by his own assessment of the performance and potentials of law and the experience of life. But the decision rendered by this court after a full debate have to be accepted without mental registration or will. The judgment is the whole judgment that is reported in this court. Question judgment. The judgment has been reported here also. This Bachchan Singh was the earlier judgment that is reported in 1980 volume 2 SCC 684. That you will also get at 349 of the that judgment. They thought that no, this will not very palatable to some of them, and the reason also given. This may not be because persons are different, way of life, so they have a different view. But we cannot do anything because of the constitutional bench judgment is valid there. Another judgment I will not repeat. Another judgment 1996 4 Supreme Court cases 119. This is also para 14. Yes. There was two judgment holding the field. One is Syndicate Bank, larger bench, larger strength, and another judgment was, my lord, National Federation. Court said that we have no other option but to accept the view of the larger bench.
Yes. Placetum A to B,
yes.
Page 126.
But only difficulty is one of the principal bench. I have my own book and mark. So here
naturally. Yeah. So the next page, page 126, plus
let's find it out. That so the thrust of my submission is so far as the locus standi point is concerned, the judgment cited by learned friend is of two judges bench. Even there, the court held that knowing fully well that the repetition may not succeed, it take this point in reply. The proposition is clear nowadays, that in reply you can take a point. That point has been taken. So in my humble submission, this person without any legal injury pleaded and proved he cannot maintain a repetition. Would your lordship continue?
Today there's a 330 called, I mean, whatever you say, because you are the architects of 330s.
The compliment or oh, those days it was compliment.
Previously it was a compliment. Now it is not a, now it's a criticism. Because now we have to suffer for that.
I will not open my mouth.
Mr. Badi, should we continue tomorrow?
Tomorrow, my lord.
Let Mr. Basu conclude today and reply 5-10 minutes if requires. I will give.
I am hard, my lord, make it hard in part. So your lordship can carry with the consent of the parties to the principal bench.
How long would you like to argue further? I mean, approximately
not more than an hour.
An hour?
Let it be concluded today.
Cannot be done. Then Mr. Badi will have to carry it forward to the main principal bench.
No, but he is from the principal bench, me also, only
Mr.
Mr.
Doc-
Ganguly will be deprived.
Nobody will be deprived. Mr. Ganguly will also be there, should be. That you will have to learn outside code.
In your
Mr. Mujumdar, you have more things to learn outside code from Mr. Vasu than inside. We'll keep it parted. We'll keep it tomorrow. Let us see. For further hearing tomorrow. Hard in part for further hearing tomorrow.
Tomorrow, my lord,
Day after.
can
Then-
you carry? Can you carry?
Ajay, hard in part, full stop. I cannot fix a date without having an assignment from the Chief Justice because I cannot break my regular bench. From there, we have to have an assignment.
Let it tomorrow. Mr. Basu has got difficulty. Virtual mode, Mr. Basu can complete. Let us see. Let us see. If it is not concluded, then your lordships can.
No, Mr. Bari, tomorrow also it won't be concluded because we from 3 p.m. even if you take up the matter, it won't be concluded. Unnecessarily, what is the use
Tomorrow
of
they will be 3:30.
Mr. Basu assures they'll be 3:30 tomorrow. He's probably
not.
pushing somebody from the balcony.
I do not know. I don't know.
So, hard in part, the next date of hearing will be notified to the parties subject to obtaining consent from the Chief Justice and shall be taken up before the principal bench. Report of the order. Mr. Basu, if you can, please have it mentioned by any of your learned juniors when I sit in the principal bench, just to remind me so that I can take consent from the Chief Justice, or you can ask, you can approach the Chief Justice directly for an assignment of a particular date, citing my order. I think that will be easier.
Yes. And my lord will be asking, this is not good.
No, I cannot ask for an assignment actually, but if it is part-hard, I can do that. Theoretically, I can do that.
The matter is over.
Because that's why I have recorded it. You can also approach the Chief Justice for a particular date. I will be bound by whatever date is fixed by the Chief.
Recorded, thereafter I have something to say.
No, I have recorded. Yes.
Recorded. But can it be taken up with the principal bench? At least so far as Hon'ble was concerned, it was not been allowed.
Why do you say?
Because the rule doesn't, then what is the use of circuit bench? If the-
No, when there is no bench, Mr. Basu, the difficulty is when there is no bench.
Then in can.
No, when there is no bench, it is assigned to us.
When there is no bench, regular bench will take up. If the bench is there.
Regular bench will not take up. A particular bench is assigned for taking up Jalpaiguri matter. That is pursuant to the assignment of the Chief Justice.
Situation but there is no bench.
Where there is no bench, if that is applicable to where there is no bench to an ordinary matter, why can't it be applied to the part-hard matters? Because the part-hard does not automatically get cancelled.
Is there? What is circuit bench? Circuit bench is facilitate the litigants here.
That logic is applicable also in between circuits, Mr. Vasu.
Not,
That is also applicable in between circuits.
But my lord, because there is a order 47. The
No, notification about
said that,
motivation.
the division bench will take up the bench which passed the order, but in the court track, this regular bench, there sits there, they should take up the review matters.
Then do you want,
I know.
Mr. Basu? Then I'll stay the operation. I'll injunct you from further acting as headmistress of that school, and I'll keep it adjourned till when I come next in the circuit.
Yes,
I can do that.
That is past license, it is not for.
No, I can add that rider that this matter is adjourned, sign it with the rider that you won't be able to function as a headmistress of that school.
Yeah, I am not for this matter. I am thinking aloud.
I don't think that's a proper logic because Mr. Basu, if in between benches it can be done by assignment, part-hard matter, even no assignment is necessary.
I think so.
And I have seen certain matters I have been taking up in the division bench, certain matters where Justice Abhijit Gangopadhyay hard in part the matters and those are being heard before from the principal bench.
Don't take
That,
mess.
no, that is being done, but that is, the chief is not saying anything.
Why not is the court?
And there no assignment is also obtained.
Judgment on court player.
No, Mr. Basu, since I have heard it in part, either I have to
Mixed with this matter.
no, this matter also because this is taken as a case example. I mean, we can either cancel the part or the Chief Justice even can assign it to a different bench of the Jalpaiguri circuit if necessary. But since it is part I cannot get rid of the matter now. Either I have to cancel the part or Mr. Basu, I mean whoever, not I mean whoever, or the Chief Justice can assign this matter to a different bench in the Jalpaiguri circuit also, whoever comes. That can also be done. But that
Hello.
tantamount to the same thing.
Don't mix up with general question.
Yes, Mr. Bari.
Well,
So
all
should I cancel the
coordinate-
Pathar?
No, all coordinate bench, taking up the Pathar matter, just a Ganguly, just a Basu,
Taking up
wherever
matter,
the circuit bench,
saying
their
what is the
matters
law?
are being taken up by the principal bench as a harding
I am
partner.
not opposing
I
that.
saw in only one matter of Justice Ganguly. I don't know of any other matter,
Justice
Mr. Bari.
Basu, Justice Basu is
No,
taking
other
up
also been
Delhi.
done. Other also done, I know.
Then I
So
will.
no problem.
No, no. This is not Justice SABYASACHI.
Your client has to go.
My client, forget my client.
Your client was in the golden period. I mean, she was appointed in the golden period.
I will satisfy us. That is, I think this is troubling my lord.
No, that is the most important factor in your case, apart from locus standi.
I will show to your lordship, my lord, why he is filing this application. Apart from my, so far this golden period.
That probably Mr. Mojumdar would be able to say in his capacity as the Deputy Solicitor General.
Yes.